Okay, so it's 9 a.m. I want to say good morning to everybody. I'm still not accustomed to seeing so many small screens here, and I'm appearing to you all from an empty hearing room at the Public Service Commission. I don't know if that we're going to have. It doesn't seem like everybody has logged on just yet. So why don't you give us a few minutes and we'll start up everything. But if anybody has any problems right now, technological problems, shoot me an email. We'll see what we can suss out. And once we have, because I have got a long list of participants here, once I make sure that everybody's here, we'll log on. More people are coming on here. So I'll give you all a minute to have a little more coffee. That's what I'm going to do.
Hey, Jeb, John Tyler with AT&T is joining.
I beg your pardon, you broke up. Who
Yes,
just spoke?
John Tyler with AT&T joining. Good morning.
Morning, John. All right, I'm sure everybody's eager to get in here and talk about everything on which we agree. So I'm going to kind of give a brief little roll call just to make sure that I have everybody whose names and contact information were given to me by council. So I'm going to start with representatives from Kentucky Power. I don't know if Mark Overstreet was going to appear. Mark, are you online? Yeah. Pam Ellis. I see you there. You're in the corner. Good morning. Eric Langley.
Yes, here. Good morning.
Good morning. And Riley Zelanka, if I said it, pronounced that correctly.
Riley is in my office, and he's actually not going to be on this meeting.
Okay, thank you. And then is there anybody else from Kentucky Power that will be appearing? All right. So for AT&T, John Tyler, who has already made himself known. What about Aaron Schwartz? Okay.
Yeah, Aaron may not be joining us this morning.
Okay. And what about Dan Reinhardt?
Dan Reinhardt is here, trying to get video going.
All right. And I will ask for those that do not have video going, and when you speak, please announce yourselves so that we know who's speaking on these matters. Thank you. All right. So for charter, let's see here. Jason Keller.
Good morning.
Good morning. I see Ms. Wallenstein here. And to me, she's
Good morning.
mid row here. Mike, Mike Chawani. How do you pronounce your last name, sir?
Very good. It's actually Chwanik. Good morning.
Good morning. Joe Crone.
Good morning.
Good morning. Eric Lannon.
Hey, good morning.
Good morning. Paul Werner.
Yes, good morning. I'm here. Hopefully you can see me now.
Cannot see you at this moment.
Okay. All right. I'm working on it.
I'm grading everything on a curve this year, so I don't think we have to worry too much about it. And then I see Jim Gardner there. Good morning. Former vice chair and former chairman of the commission. And then for Duke, I see Ms. Honaker, one of my former colleagues. Good morning. And then I see Jeremy Gibson also. Is there anybody else from Duke?
No, I don't think so. I think we're the only ones that are going to participate.
All right, and I meant to ask Jim or anybody from Charter, is there anybody else from Charter that I missed?
I think we're good.
All right, thank you. Okay, so for LG&E and Kentucky Utilities, is Sarah Judd online? All right, maybe she will join us. I know that Mr. La Follette is here on behalf of LG&E and KU, and I thought I saw Mr.
Yes, sir, Mr. Penny. I spoke with, Sarah Judd and I are texting right now. She's having some VPN issues and is attempting to get logged on.
I hope she doesn't miss all the excitement. I'm sure that's to follow once we get over the introductions. And I do want to point out that this should be streaming on YouTube, the Commission's YouTube channel, and it will be posted to our website so people can go back and watch it if they have trouble sleeping. And then finally for LG and KU is Eric Langley. I see you there, sir.
Yeah, so I should have mentioned earlier, I'm here on behalf of both Kentucky Power and LG&E KU today.
Well, you know what? I'm glad you pointed that out because I thought I'd already spoken to you. Well, good morning again. Is there anybody else that needs to be here for LG&E and KU?
And Jeff, this is Rick Lofkamp.
Okay. All right, and then for the rural local electric cooperatives, I see Mr. Perry. Good morning, Chris. How are you doing?
Good morning. Good morning. How are you?
And Tip, I see that you're in the office.
I am. Morning, Jeb.
Morning. And is Mr. Buckley online too, or is he not going to make it today?
He will not be joining.
Okay. All right. Have I missed anybody on here besides commission staff who I'll introduce later? Okay. All right. So for staff introductions, my name is Jeb Penny. I'm the acting general counsel at the Public Service Commission. I've been here for, well, yesterday was my 21st anniversary. So I've been raised in captivity, man and boy. We're joined by two other staff members. We have Ben Bellamy, who is a staff attorney, and he's been kind of guiding the regulation review process at the Public Service Commission. And then somewhere in the ether should be Cornelius Mance, who's also another staff attorney who probably won't weigh in, but he's out there taking notes and paying attention. I sent out in my invite that I thought what we would do is have some brief introductions from each of the groups if they want to make some opening statements, and then we might just dive in. I think that we made available online a matrix of the different language and comments on those sections. I anticipated that what we would like to do, if we don't get too far off the rails, is for after the comments to kind of dive in through these various sections. Commission staff may have questions on some of the proposed language or the disputes with some of the proposed language or the language the commission proposes, and then we can just use that as a starting point for further communication. If we manage to get through all of this in the allotted time today, probably what will happen is commission staff will take a lot of these points under advisement, might make some suggested changes and circle back with the commissioners to see what they would like to do, whether they would like to have another public meeting, would they like to make certain changes to the regulation. I will keep everybody updated in the regulation emails that I send out to let you know not only what the next step may be, but when we would anticipate it occurring. We are heading up on some holidays where there might be limited staff, so there probably won't be much movement over the next few weeks on this, so everybody can enjoy their time off if they have it, if they're lucky enough to have it. So are there any preliminary matters or any questions that anybody has about about this process? I'm listening, but if not, we can go forth with any opening comments, and you of course don't have to make them if you don't want to, but I'll call on people in the order in which I just randomly wrote them down on my list, if that's okay. So the first entity I have is Kentucky Power. I don't know if you want to make any opening statements or comments before we kick in. Anybody from Kentucky Power?
Well, Jeb, this is Eric Langley, and I'll just make some brief comments, and we can kill two birds with one stone, since these will be comments on behalf of LG&E KU as well. But first, thanks for the opportunity to participate in this meeting. I'm looking forward to the conversation. The comments that LG&E, KU, and that Kentucky Power have filed really fall into three categories. There are comments that address issues about fair cost recovery. There are comments that address issues that touch on the ability to manage and preserve the safety and reliability of the distribution network. And there are comments that address preserving the infrastructure cost sharing agreements with incumbent local exchange carrier telephone companies. The rules as initially proposed by the commission, for the most part, were good rules from the perspective of LG&E, KU, and from Kentucky Power. And though there were a few tweaks and a few clarifications that we had proposed in our comments, there were really only two areas of concern, one of which, the main area of concern, was the self-help remedy in the electric supply space. And we can discuss when we get to that rule what some of those specific concerns were. The other issue had to do with the way that joint users were treated under the rules. And though one of the rules, proposed rules, appropriately excluded joint users from most categories of the rules, there were a few ambiguities that we thought needed to be cleared up. But I would say that the bulk of the major concerns that LG&E, KU, and Kentucky Power have in this proceeding are some of the new ideas that have been introduced by the communications stakeholders. And the chief among them are two particular items. One is the proposal to shift the vast majority of make-ready pole replacement costs to electric utilities and their ratepayers. And we can explain in more detail when we get to that issue why we believe that that is an incorrect proposal. The other has to do with limitations on LG&E, KU's, and Kentucky Power's ability to manage its electric distribution infrastructure through standards. And one of the particular issues is this idea that the NESC ought to be a ceiling on electric distribution construction standards. At a higher level, though, one thing that we would point out is that the tariffs that LG&E, KU file and that Kentucky Power have filed aren't unilaterally forced on attaching entities. They are filed in as proposed tariffs for stakeholder participation and ultimately commission approval. And that is, in fact, the process that has unfolded specifically for LG&E, KU twice in the past 5 years, with participation by many of the entities who are here on the call today. But we'll get into some of the more granular positions on the issues as they arise. And again, we appreciate the opportunity to have this discussion and look forward to a robust one. So with that, I'll be quiet and let someone else talk.
All righty. Well, thank you very much. I appreciate that. Two birds with one stone from LG, KU, and Kentucky Power. All right. So next on my list, and once again, there's really nothing important about this, just the order in which I received the emails, would be anybody from AT&T if they would like to make opening comments.
Yes, good morning, Jeb. It's John Tyler with AT&T. First of all, we'd like to thank Commission staff for all of the hard work that's already been done on these proposed regulations and for allowing for early input in the process. We think that that is critical for the industry and for businesses and citizens alike in the Commonwealth. AT&T's comments are designed only to strengthen the final product. They are limited and fairly self-explanatory, we believe. So we will be actively listening, and we look forward to continuing to work cooperatively towards pole attachment regulations that will serve the Commonwealth well going into the future. We would point out that we're looking for just and reasonable rates and conditions across the industry for all attachers, and we believe that they can be tied directly to FCC rules by reference, that is a good signpost to utilize. Obviously, it will need to be done in a way that makes the most sense for the Commonwealth, but that should be something of a guiding principle in terms of what is currently just and reasonable across the board. So we would highlight that, but we stand ready to have a full discussion as well. We're not looking at this point into getting into substantive arguments, but rather listening and working towards an amicable solution to the extent that we can at this point in the proceedings. So again, thank you very much.
All right, thank you. All right, how about charter? Anybody from charter want to speak?
Yeah, thank you, Jeb, and to the rest of the commission staff. My name is Jason Keller. I'm Vice President of Government Affairs and Regulatory Strategy for Charter Communications, and I also serve as Board Chairman for the Kentucky Broadband and Cable Association, which filed comments with the commission on this subject earlier this fall. And I think we'd like to first thank the commission as well for taking a leadership role on establishing pole attachment regulations that we believe hold the promise of furthering broadband deployment throughout the Commonwealth. And although cable operators are investing hundreds of millions of dollars each year in building out broadband across the state, access is still limited to 300,000 Kentuckians, particularly those living in rural areas. And without broadband, as we all know, our rural areas are put at a disadvantage. But this proceeding is an opportunity to change that for tens of thousands of families and businesses. The COVID-19 pandemic has placed a bright spotlight on this issue. As our schools have moved to NTI, our doctors' offices have shifted to telehealth, and our businesses have transitioned to working from home. And Charter Spectrum is firmly committed to connecting more Kentuckians and bridging the digital divide in rural areas, both through our own significant investment of capital as well as leveraging federal and state funding. The FCC recently announced that we were assigned Rural Digital Opportunity Funding support for Kentucky, in which I look forward to speaking about in more depth when the FCC's quiet period concludes. But our ability to rapidly connect Kentuckians depends on pole attachments. Pole attachments are the lifeline of rural broadband. And without the ability to attach in a fair, cost-effective, efficient manner, rural broadband grinds to a halt. And this is a fact that has been recognized by by dozens of members of the General Assembly, local elected officials, and other interested parties, all of whom commented in this proceeding about the importance of establishing clear, consistent, and fair attachment regulation. It's also a fact that was recognized broadly by Kentuckians of all walks of life. And actually, a recent bipartisan study conducted by veteran pollsters Fred Yang and Robert Blizzard found that more than 3/4 of Kentucky residents support policies that will advance rural broadband deployment, including standards for predictable and fair pole replacement costs, allowing construction and installation techniques that can speed up deployment in our rural areas, providing for uniform rules for attaching new equipment to utility poles, and setting clear timelines to avoid costly delays. And already the comments now before you indicate that broad consensus exists among communication providers and even some pole owners for the commission to promulgate comprehensive pole attachment regulations consistent with FCC requirements to ensure cost-effective and efficient broadband and other communications plan deployment. And consistent with those requirements, there is basic consensus that costs get fairly apportioned to those that cause them, and that the commission's regulation should reflect this fundamental cost causation principle to advance timely and efficient facilities deployment. Broadband is coming to more of rural Kentucky. And the question before us now is how fast and how far we'll be able to expand broadband in rural areas. And this regulation setting process is going to play a critical role in determining that. So on behalf of Charter and the Kentucky Broadband and Cable Association, I want to again thank the commission for its important work on this issue as we look forward to being a constructive partner in this process. Thank you.
All right, thank you. All righty, Duke, does anybody from Duke want to speak?
Good morning, Jeb. We would just like to thank commission staff and the commission for allowing Duke Energy Kentucky to participate And we don't have any further comments at this time other than the comments that we've previously filed.
All righty, thank you. And last but not least, anybody from the rural co-ops would like to speak?
Yes, Jim. This is Chris Perry, and I once again appreciate the opportunity to speak upon these regulations and where we're heading. You know, as Jason just said, broadband in rural areas is critical importance to us going forward. We believe that, and we live it every day. We certainly have commented on these regulations, and we see some good and we see some challenges in those as well. You know, but I want to just start real quickly. I imagine many people on this call here have spent the bulk of their career in utility world. I have as well. I was an electrical engineer and then a CEO during a very difficult event that happened in Kentucky. The report was produced on the ice storm, 2009. Ike and Ice report came out. I want to read something the commission said there. It says the commission finds that electric utilities, pole route owners are responsible for ensuring safety and integrity of their infrastructure. This includes evaluating the impact of attaching facilities to determine compliance with industry and regulatory standards. The obligation of those utilities to make their facilities available for third-party attachments in no way alleviates their responsibility to provide for the safe and reliable operation of their systems. It goes on and it says the PSC expects attaching parties to notify pole route owners of each specific intention to make attachments and to seek approval for such attachments pursuant to the governing agreements and tariffs prior to placement. You know, I'd love to say it's gotten better in some of the rural areas with the way we've communicated, and I think it has many times. Sometimes it hasn't. But as electric cooperative, safety and reliability is at the foremost of our comments. And we want to make sure that that is continued to be considered. And as we talk about these regulations, you know, we've created great partnerships with communications companies across the state. A couple of them in particular, People's Rural Telephone and Mountain Rural Telephone, have deployed 100% broadband in rural areas. And that's in conjunction with Licking Valley, Jackson, and other cooperatives in those areas. You know, we're ready. We're excited to get broadband in some of these areas. So we want to modernize these regulations. But at the front of every discussion we're going to have is safety and reliability and timeliness that needs to be had. So we appreciate the opportunity to comment. We appreciate being part of the process, and we'll be here throughout the day to discuss this. Thank you.
All right, thank you, Mr. Perry. Does anybody else want to make any sort of opening statements? All righty. I'm not going to give you much of a chance. There being none, I think we will jump in. And at this point, I'll start to defer to Mr. Bellamy, who might have some questions on some of the proposed language. Let me ask, before we get into that, we have the ability to do a screen share where we would pull up the chart that we provided to everybody. Would there be a preference amongst you all whether we should pull that chart up for screen share, or to you all reference it on your own? I don't know which would be more effective. We can try pulling up the chart and talking to that. That way, you can loosen your ties or take off your coats if we have the screen share. But any objection to that? Oh,
I think it would be easier if we had a screen share at that function. Yeah.
Okay. So, Mr. Bellamy, do you have the ability to pull up the screen share? Let's see if I do. All right, Ben, you have presenting. You can present. Please bear with us as we work our way through this. All right. There we go. All right. Ben, we can't hear you.
There you go. Can you all hear me now?
Yes, okay, this is great. All right, easier than I
I was
thought.
sharing my screen and ended up minimizing all the controls to go to meetings. So, I'm Ben Bellamy. I'm a staff attorney here at the commission, and I, along with a number of other team members, came up with the draft for this that we were kind of basing to get comments on from all of you all. But I guess I know there are some bigger issues. It seems like there's some issues where I think the attachers and the utilities have some particular disagreements on, and I think we will get to those. But I guess just to kind of try to hit on everything, or at least things that we had perhaps some questions on, commission staff, I kind of created this chart kind of going through some of the proposed changes, and we're kind of going to go in that order just to be more systematic about the comments and maybe try to get some clarification on some things and perhaps question whether or not there's some areas where you all can reach a consensus on any point. So I guess the first I guess issue that I had a question on, I apologize. I'm trying to pull up my notes here on my other screen without sharing them on here. Is the definition of an existing attacher actually, I apologize. It's the definition of a pole. So I know a number of utilities had proposed changing the definition of a pole to limit to distribution poles. And I think the proposed definition here is that the term pole would be defined as a utility pole supporting electrical supply facilities that operates at or below the nominal maximal distribution voltage, and does not include either a pole that supports electric transmission facilities, or two, any pole, post, standard, or other structure that is used primarily to support outdoor lighting. I had a couple questions. I understand the lighting, and perhaps there's some language, if that were the only issue, perhaps there's another way to address that, to make sure that's clear that pole is not referring to outdoor lighting. But with respect to the definition of utility pole and limiting it to distribution as opposed to transmission, I guess the question that I had is, what is there a clear definition of what an electric transmission facility would be? At what voltage would something reach that level? I guess because I know, with respect to whether something is a transmission versus distribution line, there's, I guess, some debate about that. And I was curious how there would be a clear distinction, assuming that that was something that the commission was interested in, how you would clearly define that, and would the definition of that be different depending on the utility involved? I don't know if anyone had any comment on that.
Well, Ben, this is Eric Langley. I'll jump in on that. And I think the answer to both of your questions is yes. There is an actual way to define that by nominal voltage. And I think it would be different for each electric utility, although I'll let the the actual subject matter experts opine on that. One thing that I would reference though is LG&E KU's existing pole attachment tariffs, which actually do identify by voltage what is distribution versus transmission. And John, the following at 69 kV and 138 kV, are those the demarcations?
Yes, sir.
And it may be different for Kentucky Power, it may be different for Duke Energy, and it may be different for the co-ops, but they each, I believe, have those points of demarcation.
And so basically, and I think if I'm recalling from, and I may be misremembering from 046, but would each utility set their nominal maximum distribution voltage, and then based on this definition, they would set that voltage, and then the reg would then limit the pole attachments based on that the voltage that they set. Is that how this would apply, I guess?
That is what LG&E, KU, and Kentucky Power had in mind. There may be another way of skinning that cat, but that's what we had in mind with our proposed language.
And that's what I was, because the way that, and I may be wrong, and just to be clear, like, if I talk about what I think the language might mean, I'm not trying to give the commission's opinion on what the language meant, but perhaps if a reviewing court were to review it, what they might interpret it as meaning. So I'm not trying to give the commission's intent with respect to any specific language, but with respect to the way the reg is currently written, because every utility, I guess the thought is kind of that every utility might be different, and it currently allows for utilities to disallow connections based on various reasons, including capacity and safety and engineering concerns, and because every utility was different, I think the way that I read it is that would allow specific limitations to be proposed in tariffs. You might have an engineering concern that would broadly apply to specific poles, and you could propose that in a tariff, and then with respect to the particular facts of the particular utility, make that argument to the commission, and whether or not they accept it, I don't know. But instead of proposing a broad rule, I didn't know, or do the utilities, under the current proposal, do you think that the language would need to be amended in order for utilities to set specific standards within their tariff, as opposed to including a broadly applicable rule that might really apply differently to different utilities depending on their circumstances within the reg?
Yeah, I think the concern was the generally applicable rules applying to structures for which they are not a good fit. I don't think this is a threshold question of whether access would ever be granted to transmission structures, because it currently is and will probably remain the case, but it has to do with whether a specific set of rule-based access provisions would apply to those structures. And so I think, as you're suggesting, maybe the approach to transmission structure access is on a tariff by tariff basis that defines what those assets are and establishes what those processes are for gaining access, all of course subject to stakeholder input and commission approval.
This is Tip Depp. One thought I might have, and it was raised by EKPC in its initial comments, and of course, as a generation transmission cooperative, it's a little differently situated than the integrated IOUs, but it does in certain cases have facilities that are, for example, transmission facilities that are less than 69 kV. They're used strictly for transmission purposes and that sorts of things, which is, I think, why we sort of prefer the more generic language, but didn't want to lose sight of that sort of unique characteristic.
That's transmission facilities might be different depending on the utility, and I guess my reading of the current language is that it would allow both in specific instances, if there's an engineering or safety issue, on a pole that you could otherwise attach to, potentially, you could say no under a specific circumstance, but also reading of the reg, and if I'm wrong, then perhaps something needs to be changed, but I guess my reading of the reg is that it would allow proposals in tariffs to define, what assets it wouldn't be there from an engineering perspective or from a safety perspective where attachment should not be allowed, and defining it within the tariff based on the specific facts related to specific utilities. I guess that's what.
Sure, I get that. The only thought is I think, and I'm speaking a little bit out of line, so I'm not intimately familiar with their tariff, but I imagine they don't have any pole attachment provisions in their tariff because they are strictly a GMT, and so they, you're essentially asking them to file something that says we wouldn't allow that, which I suppose can be done, but that's the reason I raise it. They're a little differently situated. Okay. Yeah, go
Hi,
ahead.
this is Jill Valentine. I'm sorry, from Charter. I didn't know if you were done asking the electric utilities about what their transmission pole voltage was, but I did want to jump in when you were done. And
No, go ahead.
Yeah, so the way that
Ms. Valentine, can I ask you to pause for a second? If you're not speaking, would people please mute their microphones? We're getting some feedback. I would really appreciate that. Thank you very much. I'm sorry, Ms. Valentine, for interrupting.
No, that's fine. So the way that the utilities have proposed the definition of pole is very broad, and it would limit poles with transmission, but also distribution. And that's the problem that I have with their proposal. I'm not sure, we might be on some pure transmission poles, but I bet you that we're on a lot of distribution poles with transmission, and they're called transmission with underlying distribution. And the way the definition is written, that would exclude all those poles that we pay for in rent that have distribution, but also, some transmission facilities. So, and that is also actually, their current tariff only excludes pure transmission. And so this seems to want to broaden that exclusion. So I just wanted to point that out.
Yeah, you're talking about poles that have like transmission at the top and then distribution below, and then communications. Yeah.
No, Jill's right about that. Only in the LG&E KU tariff, the only poles that are structures that are categorically excluded are pure transmission structures. It's just that there's a separate process for transmission structures that also have distribution. That's why I said earlier, it's not really a question of access so much as it is the terms and conditions upon which that access is allowed. And we think that it should be different for plain old distribution poles versus transmission structures that also have distribution facilities.
Yeah, and that's not how it works anywhere. And I can't imagine it, as you were saying, Mr. Bellamy, that they couldn't judge it under the current access standards for safety, reliability, and generally applicable engineering purposes. I don't see any reason to have two different standards, and I've never seen that before.
Well, I mean, it's in the existing tariff, and Charter, I believe, was a participant in the proceeding that led to the approval of that tariff just 2 years ago.
Before we, I think I understand your all's comments. Mr. Langley, I did have one question. The way that the definition change is proposed, it would apply to the entire reg. And if you're talking about being able to establish, different procedures for attachments depending on the nature of the equipment, I guess my reading is, and I can pull this up really quick, but Can you all see that? I pulled up just the draft of the reg itself, but the general provision would be that the utility or a utility that owns, controls utility poles shall maintain a tariff. And then, let me see. Oh, above here, I apologize. Section 2. You provide non-discriminatory access to the poles. And, this applying Section 2 and Section 3 to whether you're talking about pure transmission or hybrid distribution transmission, it just basically is requiring non-discriminatory access subject to the engineering safety concerns, and then allows the terms to be prescribed in the tariff. And then below, Section 4 sets forth the primary procedure. If you change the definition of pole, it would exclude those from all of these. And I didn't know if your intent was to exclude it from just Section 4 alone, and then having Section 2 and Section 3 apply, where you would have, you'd have to have non-discriminatory access basically set under the terms and conditions of your tariff with the ability to exclude for engineering and safety issues.
No, I think I understand your point, and it's a good one. Here's the way I would frame it. The primary concern, as I think you were suggesting, was certainly Section 4, and then to some extent Sections 5 and 6. I would need to pull in John LaFollette from LG&E KU and Pam Ellis from Kentucky Power for some further thoughts on whether having transmission structures subject to the general obligations of non-discriminatory access would be an acceptable solution here. So John, Pam, do y'all have some thoughts on that?
I do. This is Pam Ellis with Kentucky Power. There are NERC SIP rules around transmission structures and access to those transmission structures. I don't know them off the top of my head right now, but because I'm more focused on distribution. But we have a problem with mandatory access to a transmission-only structure. Mandatory access to a distribution structure is fine. And then in poles that are both transmission and distribution, we typically treat them as a distribution pole for access, but they still have to go through transmission engineering, which is a higher cost. And we make that known up front. So we would, like I said, we would treat a hybrid pole, as you called it, as a distribution pole for access requirements, with the understanding that it's going to require a heavier duty engineering and probably more expensive make-ready costs. Did that answer your question, Eric?
I think it answered my question. Before we move on, did anyone else have any other comment on this particular topic? Okay.
Yeah, this is John. I would just say that from AT&T's perspective, the nail was hit on the head, and that is the underpinning should be non-discriminatory access for all attachers. It seems to me from our discussion that tariffs that are unfiled and will need approval for additional tariffs going forward, that the operational concerns are taken into account within those tariffs, but within the regulations, there should be an underpinning of non-discriminatory access. And that should be true regardless of whether we're talking about a transmission facility versus distribution.
Thank you.
Ben, this is Allison for Duke, Kentucky. We would agree with what Ms. Ellis had just said too about the transmission distribution poles.
Okay. Thank you all. So I'm scrolling down to, I guess, the definition of communication space. Let me see. I'm actually just going to keep going past that and see. I'm just trying to hit kind of the bigger points. So I think, we understand a lot of the comments and just So I had a question about the definition of complex make ready. So basically, I think this was made by both Kentucky Power and LG&E, that it should be limited, that the term complex make ready should be limited to things within the communication space. So I guess you would have, based on my understanding of what the proposal is, you would have the simple make ready within the communication space, and then complex make ready within the communication space. And then anything above the communication space or below would be, would fall outside of section 4, 5, and 6 of the regulation. Basically the accelerated attachment process. And I guess my understanding is the current FCC, I guess, reg, unless I'm misunderstanding this, it would be complex make ready can be both within the communication space. Anything outside the communication space is complex make ready within the definition as a matter of law. And then you can also have complex make ready inside the communication space as well, depending on the nature of the work. Is that incorrect?
Ben, that is not the way that we understand those definitions. Our understanding is that the terms simple make ready and complex make ready are specific in the FCC's rules to the one-touch make ready remedy, which is limited to the communication space and below. So earlier you had said that the part of the pole beneath the comm space would not be subject to the process, and that was not the intention of the revisions to these definitions. The revisions to the definition of complex make ready, in fact, were intended to align it with the way that the FCC uses that term, which is specific to the one-touch make ready concept. But it also touches more broadly on one of those kind of high-level points that I mentioned in the brief opening remarks about third parties in the supply space, which is something that we are seeking to avoid as a matter of rule here.
And Mr. Bellamy, this is Jill. What you said was exactly right, that complex make ready can be both in the electric space and in the communication space in the context of one-touch make ready. What the utilities are trying to do is also say that in the self-help rules for a regular make ready, when the electric utilities miss deadlines, they also want that to be limited to make ready in the comm space, which is not consistent with the FCC. So the FCC rules define complex and simple. So complex would not include electric space make ready for purposes of one-touch make ready, but for purposes of self-help, when the utilities miss the deadlines in regular make ready, it does include make ready in the electric space, and for which you have to use an electric contractor chosen by the utility. So I just wanted to make sure that distinction was clear, what the utilities are trying to do here.
Yeah.
Jill's right.
Go ahead, I'm sorry, Mr. Lane.
Jill is correct. We weren't, I was making a specific point about the definition of complex make ready, not in no way it is connected to the broader point about limiting the right of third parties in the supply space. It's a specific issue to one touch. So I don't disagree with anything that Jill just said.
And one touch, basically, if it's complex make ready, then one touch, you can't use a one touch procedure, and you can't use the one touch procedure above the communication space. So if complex make ready were defined as complex work within the communication space or anything above it, then that would also exclude the one touch procedures and limit it just to the communication space for simple make ready. Is that correct?
Right. But I just wanted to be careful not to limit it for self-help, non-OTMR.
And I did have a question. I don't know if it's right here. There was a comment about the definition of complex make ready, but then I know that some of the poll owners had proposed, as you mentioned, the self-help. And without the self-help, I guess I was curious. I know you proposed, I think some of the poll owners proposed still including basically the deadlines with respect to areas above the communication space, but not allowing self-help if the deadlines were missed. And I guess I was curious what the poll owners kind of expected the process might be if the deadline was missed. If the goal was to kind of keep things moving, how that would work so that I guess projects weren't necessarily slowed down unnecessarily. Obviously, if there's an issue, then it would have to be.
It would be what I would describe as the old FCC rule, which essentially for a missed deadline that involves make-ready work in the supply space, the remedy would be a complaint. And I think that the Kentucky Broadband Association has proposed an accelerated docket for access-related complaints, which LG&E, KU, and Kentucky Power are okay with, given that we appreciate that timeliness on access issues is key. So the remedy would be a complaint proceeding. The other thing I would point out, though, is that at least some utilities, LG&E, KU being one of them, allow something similar to this through their tariff. But the reason that LG&E KU doesn't support it as a matter of rule is because the tariff-based process, or through a special contract, they're able to obtain the specific processes and checks necessary to allow that without any compromise to the safety and reliability of the system, and ensuring that they have the appropriate protections in place. So it isn't so much a matter of whether a third party can have access to the supply space to do this make ready, but the terms on which that occurs. So that's certainly one of the undercurrents on this issue.
And I know this is kind of getting ahead of where we are, I guess, here, but it pertains to this issue. You mentioned, the accelerated complaint process. Obviously, one potential issue that would be the commission's capacity to handle the complaints. But assuming that there was capacity in the commission, and I think Duke might have made some comments too, indicating that they were okay in some instances with an accelerated process. And I was curious in what instances, from the poll owner's perspective, would an accelerated process be acceptable for resolving complaints? And if you're not prepared to answer right now, that's fine. I know you all had made that comment. I'm just curious, under what instances would that work, and how would that work in your all's mind? Because obviously there could be some complaint procedures that would be extremely, where it might be more complicated and the accelerated procedure, wouldn't necessarily work. And I think under the FCC rules, they do have some things are accelerated and others aren't. I was curious what you all were thinking there.
What we had proposed was if the commission were to embrace Kentucky Broadband's proposal, we had suggested a definition to capture what was intended by the term access complaints. I believe it is a definition that pretty closely tracks the way that the FCC has described access complaints. And I can tell you what that provision is in our proposed rules. Well, actually, I can't because it was in our reply comments, but I can find it.
Don't worry, I have them here. So basically, that's what. Go ahead.
Sorry. I just wanted to jump in while Eric was looking for that definition. I wanted to point out the distinction between going to the commission for an access complaint when there's unreasonable denials and going to the commission every time an electric utility misses a deadline. I don't really think that's the intention. The remedy needs to be that we get to use their chosen contractors, who they choose for us. The FCC's old rule is old because it didn't work. And that's why the FCC changed it to allow self-help in the electric space when the utilities missed the deadline. Obviously, broadband can't be deployed if you have to go to a complaint proceeding every time they miss a deadline. It would not work. And so I just wanted to point that out.
I understand. I guess I was thinking, and I'm honestly not trying to signal one way or the other. I was just meaning, if you're talking about limiting above the communication space, and if you did that, the question was, I'd asked the question about what procedure would be used. And so I guess I would have the question for the attachers. If you're talking about, I know they're concerned about, for safety reasons, about attachments above the communication space, and generally that wouldn't be broadband. It would be, I presume, small cellular devices and things like that. If there was an accelerated process solely to address that above the communication space issues, is that something that the attachers would find to be reasonable, assuming that there wasn't a self-help remedy?
I think the issue really, and for cable companies, the issue is the performance of electric make-ready. And if pole owners don't perform their own make-ready in a timely manner, what happens? It's not whether you want to put something in there, it's whether they perform their make-ready in a timely manner, should the self-help rules apply. And what Eric's saying is that if the pole owner doesn't perform its own make-ready in the time frames that are set forth in the proposed rules, then the cable attacher has to go file a complaint. And that's just not a workable solution. They're supposed to have electric contractors on hand so we can use them. And so if they use those electric contractors themselves, I don't know why the attacher can't. And so that's really the issue.
And we've addressed that in our written comments, why there's a difference between them hiring our contractors and the contractors doing work under specific terms that we have entered into with them and through the tariff and with the protections from the attaching entity.
And this is Tim. I've hesitated to jump in and wanted to hear comments on this first, but a few things. One, we're previewing an issue that's going to be near and dear to us, which is staffing levels to respond. And the co-ops are very, very differently situated than the IOUs are in that respect. And we need to preserve some flexibility there. But to the extent it wasn't clear, I do want to be very clear that the cooperative view is that the self-help remedy in the electric space is dangerous. We agree fully with the idea that a communication attacher hiring the contractor is different. And because of the staffing issues and because of the risk posed by then, if a deadline gets missed, someone goes out and does self-help and someone accidentally gets hurt or killed. One, we can't have that. Can't have people getting hurt. But two, it pulls us in to the liability. And I think the commission needs to be very cautious in this respect.
I did, this is kind of jumping around because it's kind of jumping to the end, but it does relate. So I think it's probably appropriate to talk about it now because you brought it up. With respect to because I understand the argument, or I understand, the pole owner's position, it's different when you hire the contractor versus the attacher hiring the contractor. And I also understand, when staffing is discussed, a lot of the attachers, you do point to the fact that, well, they have the contractors and you can just get the contractors to do the work. And I definitely understand that also. No, with respect particularly to the co-ops, I was curious regarding, I don't know if anyone had any information regarding the availability of contractors to work, for the co-ops, or if they're, if contractors would be available on short notice to perform large projects, for the co-ops.
Well, I think I'll put Chris on alert because he knows the day-to-day of this, but I do think that's going to be one of the challenges, obviously when you're talking about something out in a more rural area, to get somebody lined up to come out and do a job. And it depends as well on the size and scope of the job.
Yeah, this is Chris. Workforce issues have become a real challenge, and that's not just for us. I know that's for KU, LG&E, Kentucky Power, all of us. Line workers are in short demand. That has become very, very apparent. That's part of our concern here. Even though our contractors may be used in this process, it may be the availability. And as we're growing our systems, we would be concerned about the expectation that our contractors drop work over here for some of this work. That we would be certainly concerned about that. So day to day, that would be a challenge for some of our electric cooperatives.
And I guess just the only thing I would say to that, yes, there might be challenges, but that doesn't mean that there shouldn't be a rule, right? Everyone's reasonable. Everyone understands the challenges with, labor, but that doesn't mean there shouldn't be a rule, and they shouldn't strive to have enough contractors that might be available.
The only thing I would add is, clearly there could be a regulation on it, but if there's going to be a rule, leaving that to the commission's discretion, one, as to the urgency of the issue for timing, and two, as to how it should be resolved. You're talking about areas that are very unique and unique considerations on jobs in some of the more far-flung areas of the state. It seems to me very, very difficult, if not unwise, to try and guess those out ahead of time, and perhaps the better course would be to preserve that for the commission's discretion proceeding and addressing those particular facts at issue.
And may I, if I may, one more time, that is costly. That is an expensive thing for us to have that kind of manpower. And contractors, when we call them in for emergency situations today, I'm not saying this would be an emergency, this course of work, I understand, but our contracts with these contractors and or others that may come from other places could be very expensive, just to take that into account. When we have tornadoes, some of that gets very expensive quickly when we bring people from out of other regions.
Sure, but it would be at the attacher's expense, and they would be able to say yay or nay. That's understood.
In light of the challenges that I think the co-ops have expressed and that the investor owns have expressed, it may be worth sort of balancing that against the need or the urgency of the solution that's being proposed. And as I mentioned earlier, LG&E KU actually included, a very controlled, almost self-help remedy in its tariffs, 4 years ago. And John, I mean, aren't the instances in which attachers have availed themselves of that pretty limited?
Yes, Eric, that's right. It's been available since the 2017 full attachment tariff provision, the self-help remedy in the supply space or power space. And to my knowledge, that has not been, attachers have not availed themselves of that option in the 4 years that it's been available to them. And so I do take exception with Charter's characterization of this problem as not an if, but a when scenario, because at least for LG&E and KU, we don't miss construction deadlines when it comes to make ready in the supply space. And so we don't receive those notifications that are allowed in our tariff for attachers to use our approved overhead electric contractors to perform self-help make ready. Even though that option is available to them, the solution that's being discussed here is kind of in search of a problem, at least when it comes to LG&E and KU.
This is Mike Chwanek. Good morning from Charter. Just to reinforce Jill's point briefly, and I certainly don't want us to get bogged down at this point in the process, but I do think there needs to be a recognition that it is foreseeable that the past practices, their past experience is going to change in the coming years. And what we've seen in a lot of jurisdictions is, and this is not a criticism of any of the utilities, stresses on resources, right? And so, we are, I think, anticipating something that is foreseeable across the board in terms of more extensive build out on the broadband side. And I don't think that what we're discussing is unreasonable. And to the extent that it's balanced and it ends up serving as a backstop, if there are resource constraints, we're obviously going to be prudent about how we exercise this. But I think that backstop is necessary because otherwise what we're going to wake up and see is some pretty significant impediments and some pretty significant delays because what's going to end up happening is people aren't going to be, resourced to meet the demands. So I think we need to be sensitive to that. Thank you.
Thank you.
Ben, this is Allison with Duke. I just wanted to reiterate that we also addressed in our comments the reliability and the safety issues with the contractor issues as well. So.
Okay, thank you. So I was kind of scrolling down to, I think this is Duke's comment. It's about 807 KR, or it's section 2.1 in the reg, I'm sorry. So that would be right here. But I guess Duke had a concern about that the requirement that any cable be provided non-discriminatory, but basically that the attachers be provided non-discriminatory access, that it could be interpreted as requiring them to provide, basically obtain the right of way or the easement on behalf of the attacher. And I know there were some responses to that with respect to, I guess, some federal law that gives some rights of access. But just with respect to the language of the reg itself, there was an inclusion, and it's right here, section 2, subsection 2A. I'm sorry, a B. So the 1 indicates that you would have to provide non-discriminatory access, and then notwithstanding subsection 1 of this section, a utility has no obligation to secure any right-of-way, easement, license, franchise, or permit required for the construction or maintenance of the attachment from a third party on behalf of any new or existing attacher. And my understanding is there's at least one case from the FCC, or at least there was, that the FCC reg doesn't necessarily address the issue of whether or not the pole owner has to obtain an easement. It says you have to grant access, and I believe there's at least one case where it's been interpreted that access does not include obtaining an easement. But based on that case, and to alleviate any confusion here, this was added to indicate you would provide access, but as far as the underlying easement rights, this wouldn't obligate the pole owner to go out and get them to the extent they didn't exist already. And I was curious, do you all interpret this language differently than that?
Hey, this is Jill, and then I like Paul to step in after this. I think they're in 2.1, section 2.1, they're trying to equate right-of-way with easement, and I don't think that's necessarily true. So I wanted to point that out. They do own certain rights-of-way that, aren't private easements. But then with respect to the easement issue, I think the edit in 2B handles it, but I wanted Paul to kind of weigh in on, a legal issue that you might be touching on.
Good morning. Yeah, I'm happy to do that. Our intention and concern about this is that cable operators at least have a federal right to access rights of way and compatible easements. And we were worried by the language to the extent that it could be read as cutting back on cable operators' ability to rely on existing easements such as they are. We're not taking the position that we can require a utility to go out and get an easement for us, or that we wouldn't need to get our own easement to the extent that we sought to use an existing easement beyond the scope or in ways that's not compatible with an existing easement. But under the Cable Act and under years of judicial decisions, it's very clear that cable operators can rely on existing compatible easements, and easements generally are interpreted broadly consistent with their purposes, and generally speaking, cable operators rely pretty comfortably on existing easements, and the judicial decisions when cable operators have been challenged in their uses of existing easements have largely gone in favor of cable operators because of the way easements are drafted and the compatibility between communications uses and electric uses. So that that's kind of where we're coming from anyway.
And let me just chime in from AT&T's perspective. And again, this is John Tyler. We certainly wouldn't be looking to a pole owner to provide an easement or to seek an easement where it doesn't exist, to seek any rights of access to the right-of-way that are not currently there. So I do also believe that the edit in 2B handles that nicely. It speaks directly to that issue and to that point, and it should be, I don't think that there's additional work necessary in that regard.
And Ben, this is on behalf of Duke. You had said that we made that comment. I believe that the comment was made for that reason, because sometimes our right of ways are not just like an absolute, or our easements, and they're, could be restricted to just our usage. And I think that's what we were concerned with. Jeremy, correct me if I'm wrong, or add anything else in there on the reasoning for that comment.
That's absolutely correct. That's why we wanted that comment in there, because our easements do not cover anyone but Duke. And that's what we want to make sure that they're not trying to piggyback on our easement, because this is a continual issue today with the municipalities and cities throughout different states that at least I supervise. There's always the back and forth of, well, you let them on the pole, and we try to explain to them we have to give them access. They have access rights to the pole, but you are still responsible. You're the right-of-way holder, or you are the easement holder. They have to still permit that easement or right-of-way with whoever controls that. Duke does not cover that.
Yeah, and just to be clear on that, federal law gives cable operators an express right to piggyback on existing easements. It doesn't matter whether the easement was granted to the existing utility or, as is usually the case, one of its predecessors hundreds of years ago. The fact of the matter is that cable operators are not required to go out and get an easement in their name when there's an existing one that is compatible with its communications uses.
And I don't think we need to get, I don't think we need to get into what's required by federal law as far as who can piggyback on what easements or what the state law is with respect to how broad an easement is. Because, you all can discuss that a little more if you want, but the intent, my understanding of this language is that, is trying to address the issue that I guess has come up with the federal, to the extent that the utilities' current easement wouldn't encompass the attacher's equipment, that the pole owner wouldn't be required to go get an expanded easement or right of way to allow them. And I was curious if you all, so it's not, if federal law or state law, if whatever easement right the pole owner has, if pursuant to federal, state law, or a combination thereof, the attacher would have the right to, use that right of way. That's something that could be decided based on federal or state law. But I guess this was to interest the extent that federal or state law regarding property use to the extent that the pole owner's rights or easement didn't provide that right of way, then the utility wasn't under no obligation to go out and get it. And I guess does anyone think that there needs to be an edit to this to actually convey that intent?
No, charter's fine with the existing language, so as it's written. We agree that no one's required to get one for us. We were just trying to straighten out the right-of-way issue and the piggybacking, but I don't think there needs to be a change to the language.
AT&T would agree. To the extent that there are existing easement rights for a pole or conduit that we would like to, or a duct that we'd like to place our facilities in, that existing easement is 9 times out of 10. I can't even think of a 1 time out of 10 where it's not sufficient to allow for our attachments. But to the extent that there's some necessary easement that we would need to obtain, we wouldn't be looking to the pole owner to go and obtain that easement. So that's the point I'm making. And I do agree that 2B handles the concern well. I don't think that there's a need for additional language.
Okay, thank you all.
Ben, this is Dan Reinhardt with AT&T. I'd like to add one minor thing over and above what John said. We completely agree with the comments on A and B. AT&T did offer some draft language as a new subsection C, more as just a general rule to make sure that everyone knows that they shouldn't attach to a pole without a license agreement.
Okay. Thank you. Was that in your all's reply or in your primary comments?
It was in the primary comments. We attached a complete red line of the draft.
Thank you. So I was scrolling down to, let's see. It says AT&T's comments on section 3. Let's see. I guess I have one question just about what the current practice, and I know the answer to this for some utilities at least, and I would say I could check. Signed agreements based wholly on the utility's tariff need not be filed with the commission. And I guess I was curious, is it the current practice for most utilities? I know I've seen some from LG&E and KU where you'll file the licensing agreements that go along with your attachment tariff. But if someone's, because I know the current regulation as proposed indicates that you can file your tariff and include a requirement that a license agreement consistent with the tariff be filed, or I'm sorry, includes a requirement that a licensing agreement consistent with the tariff be signed. And I was curious, would there be any issue from a tariff perspective, of not filing those documents? If it's a license agreement that's set forth in the tariff, and you wouldn't have to file every one that any attacher signs. And I guess I was also curious, as far as current practice, do you all typically file those licensing agreements and consider them to be a special contract in that way?
Ben, this is John McCall from LG&E and KU. Our current practice is to require new attachers to execute short form agreements that are, basically recitations of the pole attachment tariff, incorporating their terms and conditions. And our practice is to not file those agreements with the commission. We do file with the commission high volume attachment agreements, which I think is what you've seen from us as
That's what I was saying.
yeah, so we do have a couple of those, but our practice is not to file the sort of standard pole attachment agreement that incorporates the terms and conditions of our pole attachments tariff.
Okay. And you followed up, I'm guessing.
And this is Sarah Judd. Just to add to John's point there, the tariff language itself does contemplate that we would have this little short form agreement that they do sign. So it is referenced specifically in the tariff, and that's why it's not considered a special contract. It doesn't in any way vary the terms and conditions of the tariff at all. In fact, it's expressly provided for in the tariff that they'll sign that one pager.
And that's kind of what is kind of proposed in this reg too, that you would incorporate some of the requirements. You know, if there's a requirement to maintain insurance and things like that, you would incorporate that into a separate contract that they would sign, consistent with the tariff. And it's not explicit, I guess it wouldn't have to be filed. And it sounds like that's actually the practice now, so there wouldn't really be any issue adding something like that, just to make it clear. The next one I had a question, it's the sign and sue provision. And I know AT&T had mentioned this, and I think Carter might have mentioned this in the previous session before the written comments. And I guess my question with this is, you know, the proposed reg includes like some self-help remedies and the ability to file complaints. But as far as the sign and sue would go, well, I'm sorry, let me go back. It includes, you know, provisions, the idea that you would file the tariff and there would be a ready-made license agreement, or you would sign a license agreement based exactly on the terms in the tariff, to kind of avoid the issue of the back and forth negotiation with the commission reviewing the tariffs upon filing, you know, with notice to customers and things like that, to determine whether or not they're reasonable. And I guess my question with the sign and sue is, under the commission's regulatory structure, would that even be permitted? Because you'd be talking about essentially a filed tariff and attempting to, I guess, prospectively amend that by signing and then trying to sue to have it amended after the fact. And this is kind of a question, I guess, for the attachers who are proposing this.
I mean, AT&T proposed it. I guess the relevance maybe would be if sometimes the small contracts that we're required to sign, and I don't think it applies to AT&T, but if my memory serves, sometimes the contracts that we're required to sign of LGE and KU, for example, stray from the tariff or have additional terms that are not in the tariff. And so in that respect, if there were to be something like that varied from the tariff or wasn't included in the tariff and they forced us to sign or else we couldn't have access, I guess that would be an occasion where sign and sue might come in. So that's typically how it kind of happens at the FCC. If the agreement conflicts with FCC rules, or if there's something in there that's unjust and unreasonable, but they force you to sign it as a condition of access, you can sign it and then sue on it.
So Bill, the way
This is Sarah Judd again. I'm sorry, I'm not aware of what you're talking about in terms of us forcing a contract that's not consistent with the tariff. As I mentioned before, it's a form tariff that we use for everybody, and a form contract that we use for everybody, and it's just like a one-page contract contemplated expressly by the terms of the tariff, and everybody signs it. It's the same thing.
Yeah, and Sarah, and I wasn't saying that you did. And what I was saying was that I know we have to sign these small contracts, and I think sometimes there's language that, you know, has been maybe not in those, but in like your construction standards or something that varies from things that we had just negotiated in the tariff. And so I'm just saying perhaps AT&T brought that sign and sue issue up, for those cases. I'm not saying that happens today. They were just asking when it might come
Joe,
up.
I think Sarah was confused because it did sound like you said that there was a different there were terms in the attachment agreement that varied from what the pole attachment tariff said. I think Sarah was saying that that's just not the case with our form agreement. Doesn't vary at all from the pole attachment tariff.
Dan Reinhardt here, in terms of part of why we propose this. The tariffs oftentimes are written for smaller attachers rather than ones with large resources. For example, you might see in the tariff very specific insurance provisions and or provisions requiring that the attacher post bond ahead of time, whereas someone as large as Charter or AT&T are capable of self-insuring simply by the size of their business. So in the instance where the tariff the tariff can't be varied by agreement through a special contract, then what this provision is getting at is the possibility of some discriminatory term being forced on a capable attacher and imposing costs on a capable attacher that need not be imposed.
So from a legal standpoint, it's John Tyler with AT&T. The simplified way of looking at this is a reservation of rights. That's what it's intended to be.
Yeah, if that's the intent, then I think that there's a problem that we hadn't spotted until AT&T explained what its intent was. Because, that's the whole purpose of the tariff filing, is to allow stakeholders to offer input if there's a provision that is objectionable to them. And AT&T has done that. LG and KU's tariffs. And Charter has done it. And so the notion that an entity that would potentially take service under the tariff can just, lay in wait, allow the tariff to move through, and then claim later that there's something unjust and unreasonable, and it doesn't seem to comport with the Commission's existing processes.
And Mr. Langley, I think that misrepresents what we're getting at here. The context of it is, if we can't reach agreeable terms on a special contract, then there would be the provision for us to sign and then deal with it if we can't reach agreement.
That's the way
I must have misunderstood. I thought you were saying that AT&T wanted to reserve rights with respect to provisions that are in the actual tariff. But if that's not what you said, then I misheard you.
Yeah, no, if you look at the section under discussion, suit provision, in the absence of any agreed for special contract, we're talking specifically here about special contracts.
And I guess that's the way that the reg is set up. My reading of it is that you would be required to file your terms and conditions, your rates, terms and conditions, attachments as part of the tariff. And you could have a licensing agreement as part of that, which is, I think, consistent with what LG&E does under their current tariff. And then obviously, if you are somehow distinct as an entity and, the general terms of the tariff don't necessarily apply to you, I think the reg does allow for a special contract. It doesn't necessarily require any entity to provide one. And I guess my question with respect to the sign and sue is, if you had a tariff on file, you have the option of accepting the tariff or trying to negotiate a special contract. But if you, the sign and sue provision, I guess my question was just whether it would violate basically the filed rate doctrine, because you'd be attempting to change the special contract or the either the tariff after the fact. And this kind of connects to another issue that, because I know with the attachers, the idea of the tariff is the attachers, would be able to intervene in a case and basically make arguments to the commission regarding the proposed tariff provisions, regarding the proposed tariff conditions and rates, so that hopefully they would be able to obtain attachments under the tariff without even having to do a special contract. And so kind of as I guess not necessarily an alternative, but another idea, and I think this was proposed also by AT&T, maybe right here below, notice of tariffs filed. Would additional notice provisions, particularly with maybe some of the smaller co-ops or anything, but additional notice provisions to put all of the potential attachers on notice of changes, I guess provide any additional protection. Because I know right now under the notice provisions, they're basically designed for the electric customers, the way that they're set up. And I didn't know if, for one, if the attachers, if additional notice provision for the tariff that would allow them to intervene in a case and attempt to, make arguments to the commission. And I'm not saying that they'd be permitted, but, provide public comments or, attempt to intervene. Would those satisfy some of the concerns? Because then you would have you'd have notice to make input into the tariff. And then from the pole owner's perspective, would amendments to the notice provisions for like a general rate adjustment such that changes to the tariff, had to be specifically noticed to the attachers present an issue for the pole owners?
Well,
I'm the notice and can intervene and then hopefully operate under the tariff without having to negotiate a special contract.
Right. And this is Tip. I mean, one, I'm not sure that would be a cooperative only. The tariff filing process has worked for years. If folks want to intervene in the process, they've always had the right to do that and continue to do that. I don't know that that's something that we would be especially concerned about, but I'm not sure it would be a cooperative specific issue either. I think the broader point is the general framework, the broad framework of the commission's regulations do seem to make the requirement for some sort of sign and sue, unnecessary and inefficient. And, LG&E KU's point about the tariff process being an appropriate form for that, I think is well taken.
And I didn't necessarily mean to single out the co-ops. I more meant some of the attachers have intervened in LG&E's case. And, because there are more co-ops, they might not be following the rate cases as closely. That's kind of what I was thinking.
Well, I would suggest that the current procedures are adequate for it, but, I understand the notice issues. In our experience, we've never had an issue with someone raising a problem if they have one.
And I don't know, maybe Paul can address this more than I, because I'm not exactly sure what the notice provisions are in the general rate cases. I think we just find out that there's a rate case, but there's nothing specific to the attacher. We just kind of find out. Is that correct, Paul? But it would be nice to have some notice that there was a change in a pole attachment tariff, or that there was a filing of a pole attachment tariff that affects the pole attachers specifically. So we'd have time to negotiate the tariffs. I just, honestly, I just don't know the process.
I think I can
But
speak
I
to
think
that.
it's good to have some notice.
In terms of notice, that notice should be provided publicly, whether it's posted in the newspaper or the like of that. I think there was a dispute with the Cable and Television Associations a few years ago with an LG&E and KU tariff where they said they did not get proper notice, but the notice had been provided in the newspaper and published on the utility's website where the proposed changes were noticed. The LG&E and KU had complied with the notice requirements, just a matter of somebody paying attention, I guess. to see that.
Again, this is John Lafayette again. Rick Lovecamp, please correct me if I'm wrong, but our approach has been to treat customers under our pole attachments tariff, receiving that pole attachment service as any other customers receiving a service under our electric service tariff. And so we provide notice that complies with what we're required to provide whenever we make changes to our electric service tariff.
Yes, correct.
Yeah, and this is Sarah Judd. We do provide the notice, as Jed mentioned, follow those rules in terms of doing it publicly, and we also notify people who had been interveners in prior rate cases. We make sure to notify them when rate cases are coming up. So when we had the significant modifications to the tariff, particularly in 2016, I believe in the notice there was an indication that among the many tariff changes, we were going to have some significant ones in terms of the pole attachment. So it was included in the statutory notices that we prepared in advance of the filing.
And Paul, I think you disappeared for a second there. We were talking about notice of tariff filings, and I wasn't clear on those rules and how the cable companies get notice, and if we've, ever gotten direct notice, and that's what we were discussing.
Of tariff changes and modifications, we generally do receive notice either through publication or through counsel who's representing the utilities generally.
And Duke Energy Kentucky would agree that there shouldn't be any new notice requirements.
Thank you. I apologize. I'm just trying to skim through here to get back to where I'm at.
Mr. Bellamy, one thing that you may intend to get back to, but I didn't hear it early on in the discussion is the definition of attachments, and I alluded in my last comments to concept right of way, and I don't know if you want to take that up later in the discussion, but one of AT&T's comments was about broadening definition so that we include all of those other spaces where attachers attach.
I think I understood the comments on that. Did you have anything you wanted to add specifically?
No. I just wanted to make certain that you had that on record. I didn't know if that was part of, I know you have it on record. Didn't know if that was up for discussion today or not, but I just mentioned that as you're moving forward.
I appreciate it. I guess I could ask one question, which is under the FCC rules, under the reg as proposed, you would provide non-discriminatory access to those items based on terms and conditions set in the tariff, but the accelerated attachment provisions would not apply. And my understanding is that's consistent with the FCC regulation. Is that correct?
I think that is correct.
Okay.
Yes, Dan Reinhardt for AT&T. That is my understanding as well.
So I had a question, if no one else had any comment on that. I did have a question, just LG&E. You were talking about, I believe it's right here. Let's see. Oh, it's about the pole attachment surveys and, a language change to remind or to allow the attachers to perform the surveys, even when they're not using the one-touch make-ready procedures. Is that basically what you're proposing here?
Yes, if I'm understanding the question correctly, it's to comport with the existing practice for an LG&E KU's tariff, which is essentially that the attaching entity will bring the survey performed by the approved contractor with its application packet. We think that actually speeds things up. And the concern we had was that the rule, as I guess if literally construed, would have required a redundant survey, which LG&E KU did not think was necessary or efficient.
So basically it's because my understanding in some ways was that some poll owners want to do them surveys themselves, and I don't know if that's why that was worded that way. And then if it allows for the one touch make ready where they can do their own surveys. And I think there's actually some language somewhere in here, I can't recall. Okay, I think it's right here. Participant and attachers. So this is referring to the one touch make ready, and I think it's where they propose something under one touch make ready, but then the utility determines that it's complex and therefore moves under the normal procedure or the original procedure. But it says the utility can elect to satisfy the survey obligations in this paragraph by notifying the affected attacher its intent to use the survey conducted. And I guess to address your concern, you could potentially just add language there indicating that a survey provided by an attacher could also, a utility could satisfy their survey obligation by relying on any survey provided by the attacher. Would you think that would be an acceptable fix to that?
It might be. The fix that we had proposed was in 4.2B1 that said unless a utilities tariff requires that as part of the application packet, but that's probably not the only way to address the concern.
I guess from a attacher's perspective, would you have any objection? I guess there's two differences. There's one question is whether or not it could be required as part of the application. And then number two, whether or not utilities should be permitted to accept any survey conducted by the attacher. I guess I didn't know if you'll have any comments on that.
Yeah, I mean, it's my understanding that we do our own surveys and suggest make ready to all the big poll owners already. But we don't do that for every poll owner in Kentucky. So taking that away would be, requiring us to do that. I would not like to see that. So I think the rule should remain that, we could be asked to do one, but we shouldn't be required to do it in every case. But the other thing that I just wanted to point out was that, the 45-day timeline that's in the rule now, that consists of, that assumes that the poll owner is doing the pre-construction survey, and that time goes to that. So I just wanted to reiterate Charter's Kentucky Broadband's proposal that if we are doing all the work up front, there's no need for that 45 days. And we had suggested a 30-day timeline for those attachers that do their own pre-construction survey, because there's really nothing to do except for look at paper after the survey's done.
Okay. I guess did LG&E have any response to that with respect to the shortening the timeline if they're doing the survey work ahead of time? And I know this might be different for the investor-owned versus the co-ops, but just from LG&E and the investor-owned regarding the shortening the timeline if they do the survey work.
Well, I guess what I would say is more time is always better, because I know these things seem like they should be easy from the attacher's perspective, but they're not. But I'll also say that the difference between a day or two on the margins is probably not a logjam issue. But having said that, and before I go further, I'd like to invite John LaFollette and Pam Ellis into that conversation, because they may have some more specific input on the time demands associated with reviewing these packets.
And I didn't mean to cut you off, but if you all were going to comment, I was curious too. What if he comes to you with a survey? What is the process? What are you all doing at that point?
So
to get to the
this
point
is,
where
I'm sorry, Ben.
you're then sending the estimate out to the make ready.
Yeah, I'm going to let John LaFollette with LG&E KU address that process question.
So once an application is received, it's routed to the correct design personnel within our electric distributions operations department. And those professionals conduct a field visit to confirm that the necessary, any necessary make ready that's called out in the proposed design from the attacher actually complies with or comports with our electric construction standards and the NESC. From there, if there's power space make ready that needs to be performed, it is designed in our work management system and an estimate is generated. Typically the out in the less densely populated areas, at least with respect to pole attachments, I don't mean population necessarily, but the workload is not as great in the rural areas, and so the time frame that's necessary to perform those reviews is often a bit smaller. The other side of that coin is travel time to the polls is increased, and that's time that's going away from other electric design responsibilities that those design professionals have. Where the additional time is more valuable is obviously in the denser regions of Louisville, Lexington, northern Kentucky to some extent. And so, we do need those extra days in those more populated areas where we're just getting a higher volume of attachment applications. And I'll just conclude by noting that the 60-day review period that's in our current tariffs, and LG&E and KU's current tariffs have been in place for as long as we've had those pole attachments tariffs. The attachers had an opportunity, and we're active in their intervention in those rate cases. And that 60-day timeline was acceptable at that point. And if especially if we're going to be seeing increased volume, as they say, with respect to attachment applications in the coming years, certainly the 60 days that we're currently allowed to review applications is going to be important.
This is Jeremy. This is Jeremy Gibson of Duke Energy. I want to add on to that. So we don't accept surveys from outside parties, but if we did, shortening the time frame, we would not agree with, because there is a significant process that goes into reviewing their paperwork, as it said, verifying that the poll information that was submitted is accurate. And as mentioned previously, those larger routes can take a significant amount of time. Not to mention that if the paperwork is not accurate, you got a lot of updating to do to correct the engineering that was submitted to you. The 30-day time frame that is proposed is, from our perspective, would do things in an unsafe manner to rush things through, and the extra 2 weeks goes a long way. I say 2 weeks, 15 days, but it does go a long way with the amount of permits that the company might receive. So we would not agree with shortening that time frame. But again, we do not allow surveys from outside parties.
Yeah, and to clarify that, the 45 days would be for the poll owners to do the survey. It's just when we do surveys ourselves, those 2 weeks make a big difference for us. And since we've already done all the work, it just doesn't seem fair to have the same time frame for a poll owner that does require their own survey or one that requires us to do it. And also, I just want to point out the 45-day time frame is the national standard, and utilities have been doing that all over the country for years.
So this is Pam Ellis for Kentucky Power. Like Duke, we don't accept surveys from attachers. We do them ourselves. But if we were, like Jeremy said, we would still have to review. And I agree. In order to go to the field, have someone to go to the field and review and make the work order. It can't be done in 30 days if it's a significant route.
Yeah, this is Chris with the cooperatives. Our procedures are similar to the other utilities, and John mentioned it. At times, in some of the more rural areas, some of the workloads may be different, and we would go inspect those anyways for safety reasons and reliability reasons, certainly. But as we get to the more populated areas around Lexington and Louisville with our cooperatives, that becomes more problematic. So we would certainly more days. Reasonable is what we expect.
I did have two
And I'll just add.
Go ahead.
Go ahead. Sorry. No, sorry. Go ahead.
Oh, I didn't know if anyone had, and I know it would be different based on, for one thing, the staffing of the poll owner and also where the request came in, and the geography of the area, but just from a typical perspective, like for the IOUs, do you have any sense of, like, if you're in a suburban or urban area, on a poll per basis, like typically how long does it take someone to go around and do a survey, or versus, in a rural area? And if you all don't know, that's fine. I was just curious if anyone had a sense of that time period.
This is Jeremy.
And I'm sorry, I don't have that information. You're right that it will vary, not just because of the density of attachments, but also because of the complexity of the electric equipment that's usually present on more urban poles. And in our experience, at least when it comes to equipment on poles, faster is not safer. And that's our primary concern with these reviews, is that any work that is eventually done on that pole can be performed safely by the attacher. And so we think that it's worth taking that extra time to make sure that this work is, that the proposed work that's in the make-ready solution is going to result in some safe work practices when the communications company is eventually working on that pole.
Ben, I would just briefly add to Jill's earlier point. I think what we're discussing here is not something that we're necessarily proposing that would be unique to Kentucky, right? The timeframes, as Jill suggested, are things that utilities and other jurisdictions have been able to, reasonably manage around. And, kind of as a bigger picture point, I think obviously the merits of each issue has to be looked at, right, in the circumstances involving that issue. But there is a cumulative effect, right, to kind of adding additional time to each step in the process. And there needs to be kind of a broader policy consideration, and obviously you'll take that into consideration as you add, what seems like a week or two at various steps that cumulatively, adds up to months. So, that balance has to be struck. And there has to be a recognition, of that when you're looking holistically at the time frame overall. So, thank you.
Mr. Gibson, did you have anything on you were going to say something about the, estimates of time? Obviously, I know it would vary. I was just curious if anyone had just a general sense of it.
It does vary. I could say from our perspective, I don't have exact timeframes, but I guarantee that we probably, due to the influx of proposals we receive nowadays for attachers, we are coming close to using that time frame, the full 45 days. Speaking firsthand from when I used to do this myself 12 years ago, it's a lot to go out and, I don't know the exact practices that are used by everybody, but I mean, when you're height sticking every single pole that comes in, communications, each attacher, midspan, power, and doing it all in a safe manner on the side of the road with what companies require, it is a timely effort to do that work.
Okay. There was a comment, and I mean, it sort of relates to just general comments that I think the co-ops have made and then some others have made. And so I thought it might be a good time to address it because you all had mentioned it. But as far as, there's a mention of in rural areas, the workload being lower. And I guess I was curious, and I guess that my take on that was that on a poll per basis, and I know there were some comments. I mean, the workload being lower, meaning there's less requests based on the number of polls being requested. And I know in your all's comments from the cooperatives, you kind of mentioned the differences in the distance between polls and things like that. And I'm curious, based on the fact that the polls are further apart and based on the fact that attachers are going to build out at a certain speed, is there really a need that for at least co-ops in a rural area for them to process as many applications as you would have to process in an urban area? Because you could, if you're talking about pole spacing, you could build out, if you're talking 150 feet versus 250 feet, you're basically almost building out twice the distance with just half as many poles. So I was curious if there was, from the attacher's perspective, is there necessarily a need to try to attach to 3,000 poles or get attachments for 3,000 poles in a 30-day period?
But Kip, let me go first, Tip, but I'll come to you. I've heard a few comments on here so far about talking about the build outs to come, and we're going to be excited about that if that comes to some of these rural areas. But it is kind of regional, Ben. I mean, a Bluegrass Energy that's not far from KU in Jessamine County. That is a very dense area with a lot of attachments, shorter spans. But, I'm not going to say the challenges are any easier in a more rural area, such as where I used to manage, Lewis County, which is Vanceburg, Kentucky, very rural, very long span lengths. But that can create its own problem with engineering design, from ice loading to wind loading to terrain to mid-span clearances. I'm not going to say it's easier. I'm just not. And some of these survey work may be just as important in those areas because you get a combine, you get some of the rural equipment that goes out there can damage that equipment just as much. So I don't want to give the impression that it's easier in a rural area. It can be different, and the survey work is still required, which can be timely. Tip, would you say anything there?
Yeah, that's all right. Thanks, Chris. And I'm glad you raised it, because when I was listening to the comments from the IOU perspective, it's kind of unique in that the facts are totally opposite in some respect, but the end goal is identical. And in the rural cooperative case, I think frequently what we're dealing with, the part that didn't get mentioned is the staffing levels are so much lower than what the IOUs have. So, I mean, if you may be right, if you hold the number of attachments constant, but you divide it out over a different number of employees, you're going to get a different result. And I think that's a significant problem for a lot of the cooperatives. And if we stick with some of these aggressive timelines and things of that nature, then that means cooperatives are essentially going to have to hire other people on. And those are costs that, frankly, an attacher is causing. And so we're just trying to, nobody has a better interest in getting the broadband to our own communities than the electric cooperatives. The people hanging the stuff are going to be the people getting the service. So all we're saying is let's be reasonable in the timeframes and the staffing levels that the cooperatives have, because they're nonprofit member owned, tend to be much lower.
Yeah, and I guess my question was kind of too for the attachers. So, I know obviously you want to get as many attachments approved as possible, as quickly as possible, so you have an idea of what you're going to be able to build and where. But I guess I'm just curious, at some point, potentially the attachments might outpace your ability to actually make the attachments. And I was curious, in a rural area, does it matter in an urban versus rural area when you're talking about, the pole spans being potentially twice as much? Like, are you going to build out, if you're filing 3,000 pole attachment requests every 30 days and assuming that those timelines are being met, eventually you're going to be having almost every 30 days, 3,000 poles approved. Is that realistically, is that an amount of poles that you're actually physically going to be able to attach to in that amount of time? When you're talking about, but particularly in a rural area where you might be talking about the mileage being doubled for 3,000 pole attachments.
Jill, you're on mute.
Sorry. Yeah, I can't tell you that, Mr. Bellamy. I think, those timeframes are basically set for everyone in terms of, what the FCC's found reasonable and what, pole owners can do all over the country. I don't know how many times we submit 3,000 attachments in 30 days, to be honest. But, maybe Joe, if you're there, who's our senior director of electrical engineering, might be able to give an idea of, how quickly we can make attachments once we get the go-ahead. I think it's pretty fast. But
yes, ma'am. Yeah, this is Joe Crum. Yeah, exactly. We get contractors to work that area. I'll take like Vansburg, for instance. We had an upgrade out in Vansburg, and we hire contractors specifically for those areas. They bring additional crews to meet our timelines to get work done.
And I guess that was kind of the question I was getting at. You mentioned you might not do 3,000 very often. And then, the co-ops, have mentioned the staffing, and if they're going to be held to the standard, it might be one thing to ramp it up, but if you have to, not getting attachments, you have to have staff on hand ready to do 3,000, at a moment's notice. Is that, I was curious if there's some room on that, at least initially in the, from an attacher's perspective, at least initially when you're talking about, them receiving the attachments. If they're not receiving attachments for 2 years and then they receive, 3,000 in 1 month, for one, is that really going to happen? But, to comply with the reg, would they need to maintain the staff to be ready to jump on that?
well, I guess I would say that, and as Joe can probably testify to, that if we had a build like that, we would be contacting the pole owner months in advance and planning and things like that. I don't think it would become as any surprise. And moreover, I do think that, having the timelines at least gives some accountability, but it also allows people to use contractors, including the utilities. And, there's no reason that the staffing couldn't be expanded if we hire contractors to do certain things, but, and maybe Joe can add to that in terms of the planning.
Yeah, no, you're exactly right, Jill. I mean, we meet with the local engineers. We let them know what we're looking at, what our plans are, and what we're submitting, and give them a heads up of what's happening. And then we, put our plans together as far as our contractors. So once those jobs are approved and the make ready's done, we can get started and we follow right behind along the make ready. Of course, once we get approval from the power company to go.
And so, Ben, just from LG&E and KU's perspective, we would definitely expect that, and that's been our experience with our attachers who have larger volume builds, is that there's extensive coordination on the front end, which we really appreciate. These projects couldn't get done without that. But just to speak to existing volume, for both of our operating companies, LG&E and KU, we've received applications in 2020 for 9,800 poles total. And that includes 5,500 that were submitted under the high volume framework that we have. With respect to spectrum, that's 929 poles for 2020. And our next highest attacher is 928 for 2020. So that's the entire year. To speak about a 3,000 pole per month application volume, respectfully, it just doesn't seem realistic up to this point.
And this is Tip, if I might jump in too. I mean, I appreciate the cooperative spirit that's been expressed here, and we're glad to hear that, and hope that does happen, and we're happy to cooperate as well. But what I take away from that is people are saying that the process really does take quite a bit long because there's a lot of planning on the front. And, there's a reason that the FCC regulations and the Federal Pole Attachment Act excludes the cooperatives and municipals because they're differently situated. And I think it's appropriate, particularly in a rural state like Kentucky, that continue to be recognized.
Thank you. I did have a question, and this, I guess, kind of for,
Ben, let me interrupt you. Do you think it is an appropriate time? I don't want to interrupt your train of thought, or if you're trying to wrap up a particular section, but we've been going at this for 2 hours. Do you think we should take a 10-minute break? Are there any objections to a 10-minute break?
No, that's fine with me.
Okay. So why don't we break for, instead of 10 minutes, 13 minutes, and get back here at 11:20? Is that okay with everybody? Okay. Hearing no objection, and if you're on mute and you object, I don't hear you. So let's break. See you back at 11:20.
Thank you.
Thank you. Okay, I think we're still waiting for some people to come back, but Ben, do you want to go back and go ahead and pull up the document where we left off?
Can you all see my screen now?
Yeah. I think we've got it.
Thank you.
We'll wait a minute or two while people come back on. Okay, I think we have a good deal of the people back. Oh, some other people might be popping back on, but anyway, why don't we go ahead, Ben, and what's your next area of curiosity?
I was curious, just the discussion we were having regarding, the number of poles that are necessary, and there was discussion of the fact that attachers will generally meet with utilities ahead of time. And I was curious, and I don't know if any other jurisdictions do this. I don't think the FCC does, obviously, but I was curious of your all's thoughts, because I know there's concern about staffing, and I know this wouldn't address all of them, but it sounds like you're basically doing this already. But in instances where it's a larger project, and whatever that larger project standard would be, whether or not the reg could include a requirement that the attachers actually provide notice, some sort of notice a certain amount of time ahead of time, indicating kind of the plan for this larger project and the route and the timetable, so that pole owners would have an opportunity to either obtain contractors or get the staffing necessary. And I guess I was curious if there would be any objection to that. It sounds like you're doing that already anyway, but and if that potentially could at least give some opportunity, so you're not essentially, as a pole owner, required to have staff sitting there ready to go to do 3,000 poles or whatever that upper limit would be. The month they come in, there needs to be some, prior notice, so you have the ability to put staffing in place to actually do it. I guess, would attachers have an objection to that? Some sort of notice requirement of that kind?
Ben, this is Jill from Charter. The only state that I know that has something like that is New York, where they have an order requiring notice when large projects are known. And so, and maybe Joe could jump in. I can't say, and I don't know if we always know within a certain time, when the project is going to happen. So I can't really speak to that, but maybe Joe can add some light to that. I don't know if there's always a specific time where we know about the project. So I just don't know.
Yeah, most projects, unless it's planned, like something Jason brought up earlier in the meeting, that we're going to know where we're going. But most of the time, it's not planned. It's we're called upon, and then we go out and we look at it, and then say, yes, this is going to be a build, and then we present it to the utilities. So Joe, question to you. I think there's a distinction, Jill, right here being made between kind of larger and kind of more routine, construction. So I think, Joe, again, I think this has been something that we could kind of consider offline, but I think there's a question, Joe, about kind of foreseeing larger projects, right? And having some kind of a notice associated with larger projects, as opposed to kind of the day-to-day kind of medium-sized activity that just happens on a more reactive.
Right.
Yeah, yes, sir, I would agree. I mean, like the gentleman said earlier, he's got 900 poles from Charter. Those are our routine bills, a lot of small line extensions. And then when we do have bigger projects, to your point, yes, sir.
So yeah,
Ben, to go to the point in New York, and Jill and I have been involved in very extensive build out in New York over the last few years. And we had a merger requirement that required us to build out to over 145,000 passings, which is obviously a very large number. And, I don't have the numbers in front of me right now, but there were points in the process, Jill, where we had, in excess of like 200,000 poles that were somewhere in the pipeline. Obviously, they weren't hitting in 60 days and they weren't hitting in 6 months. But if you kind of look at the arc of the project, the requirements were very significant. But, as Jill said, and Joe attested to this, I mean, this is intended to be a collaborative process, and we want to partner, with the pole owners, and it's not in our interest, to overwhelm them or to not give them a reasonable amount of time to staff up. But I think there needs to be a sensitivity, to the scale of what hopefully, will be coming, in the coming years. I mean, it's a good story, right? But it's going to require, resources to match it.
Right.
Ben,
Oh, go ahead.
Well, Ben, I was going to say, I think this is where the existing high volume application plans that LG&E and KU have are a good example of how this process could and should work, because they've actually executed, it's not just a hypothetical in the tariff, they've actually executed, John, I think 2 agreements, 2 high volume deployment plans, and have actually deployed under those plans. And those special contracts, which are on file with the commission, outline the notice requirements. They allow opportunity to staff up. They provide for the cost reimbursement for the additional internal or external resources. It covers all of those details so that the high volume deployment is seamless.
Maybe, and I guess I just want to stress, we don't want to have to enter into special contracts each time we have a high volume project. We want that to be part of the rules. I think that, to Ben's question, we can talk offline and see what kind of timeline we usually have for upcoming known projects, and then get back to the commission with an answer on that. Because I don't know if anybody on the phone knows the answer to that.
That's fine. I guess just from a detachment's perspective, and I know LG&E's perspective with respect to the high volume projects and the special contracts, but assuming that there was a provision for high volume projects just within a tariff or within the reg and then within a tariff, what kind of notice, I guess, what kind of period if you're talking, I know LG&E, I think your all's high volume contracts is like $2,500 or $2,500 every 30 days they can file. Is that correct?
That's definitely the case for one of them. I'm not positive on the numbers on the other. I can look that up though.
It's not a big deal, but I was just as an example, like, say you're going from just your typical work to staffing up and getting contractors in place to process 2,500 or up to 2,500 every 30 days. What kind of timeline from an investor and utility perspective would you be looking at to get that kind of staffing in place?
So we do have a ramp up period built into our high volume plan, and I'm looking at the document now, and it contemplates a 2-month ramp up period. During the first month, this is one of the high volume plans I'm looking at here. During the first month, the investor can apply can submit applications for up to 625 poles. And then during the second 30-day period, they can submit up to 1,250 poles. I'm sorry, there was actually a third 30-day ramp-up period where the attacher can submit up to 1,875 poles. And then the next month, they ramp up to the full 2,500 poles. Now, the high volume agreement that I'm looking at was contemplating a 40,000 pole build out. And so that's why you see 2,500 poles per month during a full 2-year period. But that is the ramp up period that's contemplated here. So we'd already be looking at in the first 30 days of that ramp up period, you'd be looking at a little bit more than double the amount of poles that you could submit under a normal volume scenario, 625 poles versus 300 poles per month.
Thank you. And I don't know if you all would actually have these numbers for the co-ops, but and I know from a co-op perspective, you are looking at, kind of either significantly reducing or eliminating any kind of high volume requirement. And I'm not really looking for any definitive information, but I was just curious if you had any information, kind of the level that you all will be able to get to, and it might vary, but then also the how long it might take you to get in place to put people in place, to actually just to process the applications. Putting aside whether or not there's contractors available to actually do the make-ready work.
I think that's the right question to ask. I kind of anticipated that was probably next. I don't think unless Chris tells me otherwise, then he'll jump in, I'm sure if he needs to, but there's such a range even among the cooperatives as to size that it's going to vary a bit there. And that, that range is distinct from the IOU range, that comparison. But I think that's something we can go back and kind of survey and evaluate and provide some info on, unless Chris has a little more definitive info at fingertips.
Well, I don't have the information, but I can get some data on that. But however, one of the big concerns for us is we come up with our capital spending plans and all these engineering construction plans that we've got over the next 2 years. And for us to take on a big project without prior knowledge is difficult. But, there is examples of this being done well. Mountain Rural Telephone, when they were getting some federal funding and stuff, they started meeting weekly with that local cooperative, and it's been an expansive build out that's been done timely. We've not missed deadlines, and we've done it. So I just think a reasonableness needs to be put into this. And I'm going to review more of the high volume tariff for Kentucky Utilities and LG&E, because there may be something there that we can adopt. I don't think it's going to be a slow build out or inspection for us. It just, the timing and aware that it's coming would certainly be very helpful.
Yeah, and that's why I was asking about kind of the notice and build out. So you're not required to have the staff on hand constantly to do these big projects that come around once every, I don't know how many years, but eventually you would be able to do it. But and are there contractors? I believe, and you can correct me if I'm wrong, but is LG&E and KU? I think, do you all have contractors that actually do that will actually process applications, or am I mistaken about that?
No, that's right, Ben. For LG&E, most of the normal volume application review work is performed by contractors. For KU, it's performed by KU employees. And then for the high volume work, we have brought on contract resources to perform those reviews.
Typically, it is internal staff that handles those requests.
Sure, that's what I thought. I was kind of curious what, it seems like somewhat of a specialty contract area. I didn't know, are those like national companies that do that? Or are they engineering firms that are local that have just started specializing in that, or how those contractors came about?
It's both, Ben. One is a large engineering contractor. I'm not sure if they're national or not, but they're definitely regional. more than just the state of Kentucky. And then the other contractor that we use is a local operation, I believe.
Thanks a lot. But they're basically engineering firms, though.
Yes, sir, that's right.
And if I may add, Charter uses those engineering firms to fill out their applications and do the pre-construction surveys too, to give to LGE and KU.
Okay. Thank you.
Yeah, and to my knowledge, they're not actually the same contractors, but they're, it's the same type of firm. They're different firms, but they do the same type of work.
Right.
I was kind of moving on, just completely changing the topic, but regarding the billing, I think there was a number of comments kind of about, and I'm just going to look at just LG&Es here with respect to section 4.3a, a detailed itemized estimate on a pole-by-pole basis where requested. And I know, I think Duke made some comments too about changing that and making it, yeah, right there, reasonably detailed itemized estimate. And I think you removed the pole-by-pole basis. I was curious, when you're doing the estimates, it sounds like you're kind of putting them into a program. I was curious, how often, for the estimates, how often are you getting the pole-by-pole requests? For I guess the IOUs that are doing more of these, is that often, or are you generally able to give just a general estimate based on the number of poles?
From a Kentucky Power perspective, it's usually general. We're not getting that many pole-by-pole requests at the estimate level. It's more once we provide the overall estimate, a look at pole-by-pole, which ones are probably the most expensive, and then the attachers are choosing to go underground to avoid those poles. But we've had very few requests to my knowledge of that pole-by-pole breakdown.
And Ben, this is John. I'm aware of one request that was just like Pam described. Not applicable to the entire cost statement or estimate, but with respect to particular poles within an estimate. There's been one example of that. That's the only one that I'm aware of.
Go ahead, I'm sorry.
Yeah, and this is Jill, and I think that's an important thing to have is, all it says is that we can request pole by pole. I'm not sure all the construction folks know they can do that, but I think it's very important to be able to do that, not only for what Pam said was that it helps make decisions about whether you want to build on a particular pole, but, a lot of times we just get very vague invoices, and it's very difficult to tell, what's being asked of us to be done, number one, and then number two, which project something goes to, but also, in the future, we're going to have to keep track of all this spending for, certain money that we talked about earlier. And, there's going to be a requirement to kind of keep better track of that. And I think just having that ability to request rather than taking that out, I don't think it'll be abused, but I think it's necessary to have the ability to request a pole by pole when it's necessary.
This is Jeremy. Sorry, thanks, Ben. So yeah, our design system is not set up to provide a pole by pole. If we were to provide a pole by pole, that would take a significant amount of time, not just design wise, but as well as getting an estimate for each individual pole, as the system's not set up for that. So, I know currently I think FCC timeframes, and one of the lawyers, please correct me if I'm wrong, but one of the FCC timeframes allows for 15 days to provide a make-ready estimate. And if you got a significant build that you have to do that on, and when I say significant, I mean a 30 to 40 pole job, that's going to take a lot of time to do. And as Pam mentioned, we don't see a whole lot of just individual pole requests. It's more anywhere from, I'd say on average, probably 20 polls, if not more, per request. So to give that out to each entity on a poll-by-poll basis it's just going to take a lot more time than 15 days, I can tell you that.
Well, and then one of the other points that the electric utilities have raised, and I think that this is certainly true for LG&E, KU, and for Kentucky Power, I believe Duke may have raised a similar point, is that some of the charges in a job can't be broken down on a poll-by-poll basis. So at bare minimum, the rule would need to account for the fact that some charges, like rolling a truck to the job site, that didn't change because you pulled 2 poles out of a 30-pole application. The charge to roll the truck is the same. There are other fixed costs involved as well, like traffic management and so forth. So there may be some charges under some estimating systems that can be broken out on a poll-by-poll basis. Jeremy's system, Duke's system apparently cannot do that. But there are going to be some charges that just are not severable on a poll-by-poll basis.
And that's kind of what I was getting at, I guess. When you send the final bill too, there's, I think, the same language that says poll-by-poll basis. And I guess I was curious if there is some consensus. Generally, I guess you're going to have like the typical polls where you might have, 50 polls and, 99% of them or 90% of them, have basically the exact same cost because they're essentially identical polls and you've done them together as a group. But, there might end up being one poll in that group that for some reason, either during the survey process or when you went to do the work, it was determined that needed some additional work for some reason. Whether, there was some damage to it or something, I don't know, that might place that poll outside of the normal cost. And I was curious if there was, from the attachers, like if all of the polls costs are, essentially identical, is it getting it collectively acceptable if they were to note, if you requested it, any poll that, deviated from the norm? I don't know how that would actually be workable, but I could see breaking down every poll when you're using an estimating system or the costs are all shared, probably could not make much sense. But then from the attacher perspective, if there's or if there's a handful of polls in there that are going to cost significantly more for some reason or another, that those, upon request would be noted. I didn't know if there'd be any way to actually do it that way instead of having a requirement where you actually have to break out every single poll, including the ones really that are just, business as usual. This poll, there was nothing really unusual about that poll.
This is Jill, and maybe I'll have Joe answer if that's something that's possible. I mean, I guess the problem is that sometimes we just get, make ready in a total. There's not even any breakdown at all, not even what needs to be done. So I guess, Joe, if there's some way to limit a request on a poll-by-poll basis, I can't think of one, but maybe, you have more experience with make-ready estimates than I do. When is it really important to get a poll-by-poll breakdown, I guess is the question.
Yeah, well, we roughly, when we budget our projects, we use an average dollar amount that we feel make ready. Let's just say it's $300. Going through that poll line, all of a sudden we have 10 polls and we know it's $3,000 and we get a bill for we get a bill for $10,000. What threw that off? Why did that become $10,000? And then we need to understand what poll, what issue has to be done in those 30 polls or 10 polls, excuse me. And then we need to decide whether we're going to continue to go aerial or make a move to go underground, depending on cost.
And what would you, go ahead.
I was going to say, if you received an itemized bill as opposed to saying make ready, even if it didn't identify the poll, would that provide sufficient information for you to determine what is causing the issue as far as the cost goes?
So Joe, I think the question is if, if the make ready wasn't broken down on a pole by pole basis, would it still be possible for you to verify whether the make ready costs are reasonable in a particular project?
Assuming that the bill is still detailed and itemized.
Well, if it's detailed and itemized, we'll be able to see what we need to, what's driving that cost.
Okay. Thank you. Did anyone else have any comments on that subject?
This Jeremy would, excuse me, this Jeremy Gibson with Duke again. So when we get requests from attachers, we provide a high-level estimate of a pole by pole based on previous estimates, but it's not, because as I mentioned before, our design tool does not allow a pole by pole unless you do a work order for every single pole, and that's what would take a significant amount of time. So we try and provide the best high level of a pole by pole and define some sort of explanation of what the work is, but it is not itemized and it is not detailed, because we don't know what that is until we get into the build, and we don't, that's not all put together until we know if they're wanting to proceed with make ready based on the estimate that we're giving them.
Is when you're doing the survey, I guess my understanding is you're determining generally what work would have to be done on each pole. Is that not accurate?
That is accurate. If you're, when you're doing the design, you need to figure out what needs to be done on each pole. That is correct. But when you're doing the design in the system, it does not allow a report to pull out for a pole by pole cost. It's, as far as I know, I've seen that without creating a separate work order for each and every pole.
But Jeremy, can I clarify something? Ben asked about the survey, which we do, and we provide what make ready needs to be done on each pole, but you guys do the make ready design, which is different. So I just want to point that out to Ben. There's two separate things going on here. There's the survey where make ready is identified, and then there's the design of the make ready, which is what I think you're talking about, Jeremy. Right? But like how much it would cost.
Yeah, I'm talking about the actual design, yes, right. As far as, but I mean, the survey and the design kind of go hand in hand, because the survey is what gives you the information for the design, so.
But we're doing the make ready survey, aren't we giving you on a pole by pole basis what needs to be done? I guess I'm trying to understand, like when we give the packet.
No, we don't accept that from outside parties. We do the survey ourselves. So
you guys are doing the survey.
That's correct.
Jeremy, I did have a question. When I was referring to itemized or detailed and itemized, I was talking about not on a pole by pole basis, but itemizing the estimated charges based on that particular application. And when you're doing the estimate, is that estimate taking into account like the work that you are anticipating on that group of poles, such that you would be able to itemize the cost in that way? And if there is a significant change from a typical pole, it would be reflected in the estimate.
So what's your definition of itemized? I mean, are you talking a full breakdown of every nut and bolt, or are you talking a high level?
Not every nut and bolt, a high level itemization. It says the proposed language is reasonably detailed and itemized estimate.
Yeah. And that's what we feel like we're providing today at a high level. It's I don't think we would ever provide every nut and bolt, but it's what we feel like we're giving today. We feel is a reasonably detailed, itemized estimate based on other jobs we have done in the past.
Thanks a lot.
But Ben, this is Pam with Kentucky Power again. The way Jeremy described their estimate is different than how we do our estimate. In order to do our estimate, we put every pole into our work order system and design the work order, and then say here's the estimate, here's the work required. But again, breaking it down pole by pole is difficult because some of the charges on a pole are attributed to our work and would not be part of the overall estimate that we would provide. So if we have a maintenance issue that needs to be taken care of while we're touching a pole that Charter wants to attach to, I'm not going to charge that to Charter. I'm going to eat that cost myself. And it would be very misleading if I tried to put it in a pole by pole breakdown, as well as, like Eric described, flagging, right of way clearing, things like that. I can't get to a pole by pole level.
And just from the cooperative perspective, I mean, the pole by pole, I think, would be unworkable for all the cooperatives. But what I really hear is we've got multiple systems, and the idea of, reasonable detail for each individual system, I think is probably where we're pointed.
Thank you all. Did anyone else have any comment on that?
I guess I'm just going to say one final thing, and I don't want to sound like a broken record, but all the rule says is a request. And I feel like we should be able to ask for, in certain circumstances, a breakdown of make-ready costs on a pole to understand what the charges are. So I guess I'll just leave that there.
Does the rule currently state upon request? I thought it was basically written in mandatory language.
It says where requested, on a pole by pole basis where requested.
It does on a pole by pole, yeah. On a pole by pole basis where requested and reasonably calculable.
It's effectively not much of a standard because it gets requested for everything, and we're back to the problem. I would think that would be encompassed in reasonably detailed that we're willing and capable of being done. Of course, we've got intervening argument for that.
I agree with Tim. That's the problem, is when a request comes on every single job and every single poll that comes in, that's then there when it becomes the problem.
Sure. Thank you all. I did want to, and I don't know where this is in the chart. Let me see. So I'm actually looking here at section 4B. This was a comment from Kentucky Power, Duke, and the co-ops, and I think LG&E might have made a somewhat of a similar comment at some point. But basically about the the deadline for make ready. And having an issue with that, and then I think there was some discussion of the fact that it wouldn't allow, doesn't allow for delays, and it says it's unreasonable. But I was curious about the delay portion, because there is language in that does allow for delays of make ready, and I guess I was curious. What type of delays do the poll owners think would arise that wouldn't be covered by this allowance? And I'll find a section really quick up on this.
So one thing Duke specifically has to deal with is hurricane season. And this one has been, specifically this one has been pretty bad and has delayed a significant amount of work. So for that is a yearly issue we have to battle in our other territories where we have to send crews to get customers back on.
Okay, so the hurricanes are delaying work here because you're sending crews down to those systems?
Yes, to help out with the restored power outages, yes.
And so here's the language I was talking about. So deviations from make-ready timeline. You may deviate from the time limits specified in this section during the performance of make-ready for good and significant cause or good and sufficient cause that renders it infeasible for the utility to complete make-ready within the time limit specified. And this language, I think, comes directly from the FCC reg or very closely from it.
Yes.
I guess I'm curious, are there delays that owners would anticipate as being, reasonable that wouldn't fit within this language? And I recognize the language, is subject to interpretation like most language like this, but is there some specific tweak as far as a deviation from the timelines, whatever those timelines end up being, or whether or not they exist or not, is there some deviation that you all think is necessary beyond this deviation?
Well, Ben, this is Chris, and I can give just an example of something that we've seen in some of our cooperative systems. Right now, one of our co-ops is doing an extensive build out of substations, three-phase conductor transmission lines to a steel mill in Meade County, and they're using all their resources mainly right now for that. Now, if we get a high volume request to come in behind this, there are challenges with that, and then consider hurricanes, COVID, and other things that may be on this. I'm just that's probably a sufficient reason. I'm with you, but I'm just saying that sometimes constraints on larger jobs could do it. I would assume you put us in the place where we got to pick between the job if it's gonna. That could be a challenge for at least us on some other big construction projects that are already underway.
Okay, so prioritizing, would you violate the standard by prioritizing another job that you're working on over this? And would that, and obviously you can't spell out every reason. I just tried to say good and sufficient cause, and potentially could encompass a broad number of things, but obviously I guess there is some issues on the margin where you might not be sure it would cover something that you wanted to cover, and I guess that might be the issue.
And Ben, I would just say that, the reason that was brought up was because they didn't want to set a time frame for make ready. As we've been discussing, this is all cooperative. We're not going to do anything if they're a few days late. They already, the electric utilities have 90 days, then they can do an additional 15. Then they also have an out for good and sufficient cause. If there's no time frame, if there's no outer limit, if there's no rules at all, then, I don't know what the point of adopting rules is. So we have to have some ability. And also with regard to labor, that's exactly what the contractors cover. Right, the ability for us to use the electric utilities approved contractors. So it's all supposed to work together.
Yeah, and I would add, Ben, to Jill's comments. We're expecting that kind of reasonable judgment will be exercised here, and again to acknowledge our experience in New York, right? We're dealing with events like today's major storm event, and there's obviously been windstorms and everything else, right? And we're not piling on, as we recognize, we're dealing, quite frankly, with service outages at the same time the electric utilities are, right? So we understand there has to be some expectation of reasonableness here. I think our concern is that kind of the exceptions not swallow the rule, right? Where there be, I'm going to make an extreme statement just for purposes of illustration, where all of a sudden for 3 months during hurricane season, right, from July to September, there are no deadlines because people have mutual aid commitments to send crews to Texas, right? And I'm using that as an extreme illustration, but that, there has to be some expectation that even when there are challenging times during the year when folks have hurricanes or ice storms, that people do their best to be prepared and work towards meeting the timelines to the extent.
This is Chairman too, so that's one of the very issues we had recently with an attacher. I'm not going to name, but they were not happy that their timeframes were coming up, and we had it scheduled. It was going to be completed in time, but we ended up having to send crews. And he goes, I understand people need power. He goes, but, and so it was kind of a little frustrating that there was lack of concern for people without electric not being a priority, which is number one priority, I think, to probably every utility, getting people back power. So it was that lack of understanding in that scenario. I couldn't comprehend it. And that's kind of what it sounded like just there for a second, unless I was misunderstanding that. I understand, we have to have resources back, but when you want to get people's powers back on, people might have medical conditions they need power, people might need, heating, air, depending on the elements, it's pretty important. So that's why these crews are sent to other areas to help out, get people back to their homes and being able to utilize the things they need, which is broadband, internet, power, everything like that. So that's just kind of what I've seen recently as far as, how we have to send crews to other areas. It was kind of like, we understand, but we need our stuff too. So that's just wanted to make that noted.
Yeah, I think I would just so my comments are not misconstrued, I think we are very sensitive to storm outage issues. I mean, we work with the electric utility during those processes, right? Poles are being replaced. That entire exercise is very much a coordinated partnership, right? So that's not something that we're insensitive to, but there has to be, again, some balance, right? Where people are kind of expecting that they're going to do what they need to do in terms of storm response, and then pivot back to something that looks like business as usual, to the extent that they can. So I think there's nothing about then kind of this language that suggests that kind of people won't be reasonable in how they manage this and their expectations with each other.
Thank you. I was going to kind of go back up here actually to something that we kind of skipped over and I wanted to go back to, which was, I think, a major sticking point between the pole owners and the attachers, or at least some attachers, and that has to do with the ILECs. I think the current definition excludes ILECs from the definition of new attacher, but doesn't necessarily exclude them from the definition of telecommunications carrier. And I think my reading of the comments is effectively that a lot of the electric utility pole owners want ILECs excluded from the definition of broadband provider and telecommunications provider, and conversely that some of the ILECs want to be included within the new attacher. Or I guess the ILECs aren't included if you have a joint use agreement. So shall not include a utility with an applicable joint use agreement. I was curious because the way that I read it as written is that Section 2, which requires the non-discriminatory access to poles, would be applicable to people that have joint use agreements, and Section 3 would also. To the extent it was necessary and, there wasn't a contract filed, a special contract, which I think, there would be. But then Section 4 wouldn't, because they would be excluded from, basically that expedited procedure. So I had a couple questions, and it was, I guess for one, are there any ILECs that don't have a joint use agreement with electric distribution companies that anyone is aware of, obviously? I'll take that as no one's aware of any. And I guess for the ILECs, if the ILECs could, if the ILECs proceeded just under the pole attachment tariff like other telecom utilities, I guess where would that leave the electric distribution utilities with respect to their attachments on the ILECs poles?
Yeah, Mr. Bellamy, Dan Reinhardt with AT&T. While there's not a statutory right in the federal side for the power companies to be on AT&T, AT&T would not object to inclusion of a requirement in the rule. We're not speaking for other ILECs at this point, but AT&T here, as in other places, is willing to make the commitment that we would allow power companies on our poles.
I guess you would effectively, though, they would have to use your poles. So, would the commission then have to regulate the attachment rate separately for those attachments, if that were the case?
Our current attachment, basically, we would offer the tariff rates that we have in our tariff presently to the electrics.
Ben, speaking for LG&E, KU, and Kentucky Power, I don't think the issue is so much the reciprocal obligation of access. And so if that was the extent to which the rules were applicable to joint users, I think that's something that the electric utilities could probably live with. The concern is giving joint users these other rule-based rights, which are addressed in a fundamentally different way through existing joint use agreements, under which both parties own a significant number of poles that the other uses. And so what LG&E, KU, and Kentucky Power had proposed was, in essence, using the existing language that the commission had proposed in section 1.9 of the definition of a new attacher, and putting that same language into the definitions of broadband internet provider and telecommunications provider. But arguably, and to Mr. Reinhardt's point, that may have been throwing the baby out with the bathwater, because the main issue that we were attempting to address was not the access issue, it was the other issues, but including but not limited to sections 3, 4, 5, and 6. And I would note that there's already an existing, and there has long been a right for either party to seek relief from the commission under these joint use agreements. They've been regulated by the commission for many years. So it's not as if either party, the electric utilities or the telephone companies with joint use agreements, are without remedy.
And I understand that. I guess I kind of saw two issues. Number one was, I guess the policy issue of how ILEC should be treated. And then number two is, which I was going to get to too, is with respect to the current language of the reg, like, how do we see that being interpreted? I guess because if the commission's, already regulating the joint use agreements between electric distribution utilities and the ILECs, if, I know they argued that KRS 278-170 would be applicable, regarding the discriminatory or non-discriminatory service. And the way that the reg is written in its current form, I think this section 2.1, would probably be applicable even if there's a joint use agreement. But the distinction being that if there is a joint use agreement, that the parties aren't necessarily similarly situated. And so treating them differently, but not necessarily unfairly, wouldn't necessarily violate the regulation. I don't know what anyone's position on that is.
No, I think you're right. I think under the existing law, the ILECs aren't allowed to treat the electric utilities unfairly and vice versa. And if either thought that they were being treated unfairly, they would or could at least bring a complaint to the commission for resolution. But I think you hit really the nail on the head, Ben, when you noted that they are not similarly situated because these are different, very different agreements in many different respects. And that is why I emphasized at the outset that the actual duty of access is not the main concern here. It is the other issues within the rules that are of principal concern.
And the reason I was asking about the electric utility access to the telephone poles, because I know you all raised that as an argument for not allowing the ILECs to use basically the rates and expedited procedures of the other attachers, because, if they can take advantage of those, then that kind of cross-bargaining power in part is what allows you all to reach an agreement with respect to your attachments on their systems. So if they were using the exact same rates and attachment procedures for as all the other attachers, then correspondingly there would have to be some regulation almost identical to with respect to your all's attachments, or at least some way to address the fact that you all would have to, the electric utilities would have to use their poles, but wouldn't have any kind of necessarily bargaining power to offer anything other than, just to pay for it. And if, they're the only one there with poles and you have to pay for it, then arguably, they could essentially set any rate they want unless the commission steps in and starts regulating that too. And I know that was kind of one argument you all made. And so kind of my follow-up to the attachers is if the attachers can use, the rates and the expedited procedures of any other telecom utility or broadband company, how, I know you had indicated that for AT&T, like you'd still let, the electric utilities use the poles and things, but how would you propose that the utility, that the commission, if that were to occur, how would you propose that the commission actually ensure that what you're charging for one, that you provide access and, adequate facilities, and number two, that what you're charging is, a reasonable rate for those facilities? Would we have to develop an entirely new, regulatory procedure? And this was a question for the attachers. If you have an answer, if you don't, that's fine.
I think, power is Dan Reinhardt with AT&T. Obviously power is on AT&T and AT&T is on power poles. We have indicated in our comments that we disagree with Mr. Langley's position as to the business of the companies being similarly situated. And I think that we would find that the rates, procedures that are in the commission's rules of practice right now would be adequate for establishing the rates applicable for telephone on power and power on telephone.
Okay. And kind of a follow-up to that, as written under the current reg, and I'm not trying to telegraph anything what would happen here or anything, because honestly, I don't know. I'm just trying to understand what your all's understanding of like the reg current language is. Under the way it's currently written with new attacher and that being applied to or excluding people with a joint use agreement, says shall not include a utility with an applicable joint use agreement with the utility that owns or controls the pole to which it is seeking to attach. I guess, I know the ILECs, a lot of them currently do have joint use agreements. And so, that's what's governing the relationship. I don't know what the period of those agreements are. Once those agreements expire, would that same concern arise, I guess, with respect to what happens to the electric utilities facilities that are on the ILEX poles? Because, as it's written, once that expires, would the ILEX then be able to use the, as any other telecommunications carrier? And then, if that happens, then there's, a lot of potentially decreased bargaining power with respect to the electric utilities' access to the telephone poles. And, how would that circumstance be addressed, I guess? And if no one has a comment on that, I guess my reading of it is, I guess one question I would have with that is how long are these joint use agreements like under the current agreements?
This is John Tyler with AT&T. I think that the terms and conditions are different depending upon each party to a joint use agreement. So I can't give you an overarching statement in terms of how long those existing agreements will be in effect, but they certainly have been equally bargained for. I don't necessarily agree with the idea that once those agreements go away, that there will not be arm's length bargaining between the parties. I think that remained the case to the extent that we have a desire and a need to be attachers. That is not going to subside. So there will be puts and takes regardless. And I don't think that bargaining power goes away. But I do think that it's very important to have a stopgap and to have something that is across the board applicable. Because otherwise, I think you have a real difficult time in terms of writing a regulation that somehow will take into consideration each and every individual commercial or party-to-party agreement. I don't think that that's really tenable. I think that if non-discriminatory access is the backstop, then reciprocal access is necessary, and ILEC should be treated equally throughout the regulation.
So Ben, I agree with most of what John said, but I think that actually speaks in favor of retaining the existing joint use agreements under the commission's jurisdiction, which they have always had. It's not as if these agreements were negotiated outside of the commission's jurisdiction and are now suddenly within it. They've always been within it. Each party has always had the right to seek relief from the commission if they felt aggrieved by the terms. But given the variability, given the complexity, and given the difficulty that we're having just here in this conversation, figuring out how you fit this square peg in the round hole, I think that speaks volumes towards retaining the existing paradigm, which is the joint use agreements control the entirety of that relationship, and each party has the right to seek relief if necessary.
Thank you. Did anyone else have any comments on this subject? And I don't know where this is in the summary, so I apologize, but I did have a couple questions regarding the cost of poles and who bears the cost of a pole with respect to make ready. And I know a number of attachers kind of make comments on this, and I guess I was somewhat confused, and I just wanted to clarify before, we discussed it, exactly what you were talking about. I guess there was discussion of basically the utility bearing I guess I'm wondering, are the attachers suggesting that if the utility pole is in perfectly fine condition, except for the fact that there's no capacity left on the pole, and that there's no room for them to attach, and say, a pole's been in place for 30 years, and honestly don't know what the general life of the pole would be, but say it's 50 years, and you're requesting that they upgrade, get rid of those poles and install it, despite the fact that they're not in bad shape, they could continue functioning for the remaining life of 20 years. If the attacher wants them to get rid of that pole to put in a bigger pole to accommodate their attachment, are the attachers alleging that, or is it their position that the utility should pay the cost of putting in that new pole because it would benefit everybody? Or are you saying that the utility should cover the cost of the poles only in situations where you go to make an attachment, there's capacity on the pole, you go to make an attachment and determine that the pole's rotted or there's some other issue with the pole and it needed to be replaced no matter what, that in that situation, the utility would have to bear the cost of putting in the new pole? So I guess that was the question I had for the attachers, what your all's position on that was. I think you might be muted.
I'm sorry. I'm going to let Paul talk about the issue where the pole needs to be replaced and the cost sharing when the pole doesn't necessarily need to be changed out, except for we want to get on the pole. So that's one issue. And then the latter issue was if there's a rotten pole, if it's already out of compliance, we don't think we should pay for that pole. But I'll let Paul handle the former issue with the pole replacement thing, which I think you're most curious about. Paul, are you there? Hang on a second.
You're fine.
Paul, are you there? All right, well, since Paul's not there, our position, and I think we attached our brief to to our opening comments, is that because, the poles have a certain life left, we would pay just what the value of the pole is. And that's the cost that we're causing, is the early retirement of that pole.
Hey, Jill, can anybody hear me now?
Yep.
Hey, sorry, I don't know what is going on with my system here, and I apologize. Okay. We're in the middle of a pretty big snowstorm here in the Northeast, so but I do want to weigh in on this point, and we put this in our comments, but we want to emphasize that particularly when it comes to rural deployments, pole replacement costs are a major factor in the economics and the decision making around whether we are able to deploy broadband economically, and we have to make business decisions based on that. And so the typical rule has been that attachers generally must pay 100% of the cost. But the reality is that even in those circumstances, the utilities actually derive substantial benefits from a pole change out. So what we have suggested and recommended is a more proportional and appropriate sharing mechanism based on the main rule that looks to a cost-sharing function based on the age and depreciation of the pole. So the attacher in that circumstance is basically obligated to pay the cost that it actually causes rather than for the betterment that is received by the pole owner based on the replacement of an existing pole with a taller and stronger and newer pole. So under the main rule, what the attacher is obligated to pay is really based on two components. One, the stranded investment, basically what value is left in the existing pole. And then two, the difference between the cost of the value of the replacement pole and the pole that would have been installed but for the attacher needing to have the pole changed out. So what we're looking for the commission to adopt is a rule similar and based on the main rule that's also being considered now at the federal level by the FCC that really provides for a fairer and more proportional sharing of the costs of a new pole when the utility actually receives substantial benefit from that. And that's a rule that is designed to speed broadband deployment in rural areas like this commission's focused on here.
So, and I'll ask if anyone else had a comment, but just to confirm, what you're saying is, and I know it is in your comments, but basically, you would basically pay the stranded investment. So if there's 20 years left on the pole and whatever the value of that 20 years is, you're going to pay that amount. And then if otherwise the utility would have put in, a comparable pole to that, but they're putting in a larger one because of your request, you would pay the cost difference between the smaller one and the larger one that they're putting in. Is that what you're saying?
Precisely.
And then that would be like the make ready cost. As far as the way the reg's currently set up, the rates would be in the tariff and, I think the commission would try to set them based on, the cost causation. And, I know the commission has some orders on it and stuff too, but to the extent that, costs of poles were attributed, through rates, just the normal use of the everyday use of a pole, going forward, would the attachment position be that that a portion of that cost of that pole as it goes through its useful life that wasn't paid as part of the make ready work, to the extent that that's attributable to the attachers, that those amounts would be included as part of the rate that they pay?
Right. So there are two basic costs that attachers generally pay, right? One is make ready, which generally consists of incremental costs caused by the attachment. Then there is the annual recurring rental charge. And in Kentucky, that rate is a fully allocated rate that includes a pro rata share of the entire cost of the pole. So to the extent that new poles are added into the utility network, those become embedded in that annual rental rate going forward. So the utility is getting two things in a cost replacement and in a pole replacement scenario. One, it's getting payment from the attacher in the form of make ready to pay for the costs caused by the attacher. and then every year thereafter, the utility is receiving a portion of the cost of that pole through the annual rental charge that is imposed on the attachers.
Ben, I guess the sort of the underlying issue here is whether the electric ratepayers are supposed to bear the costs of pole replacements. And Kentucky Power and LG&E KU put some comments into the record. When Kentucky Power submitted its affiliate's response to the National Cable Telecommunications Association petition on this very issue. But the whole proposal, which, by the way, exists only in the state of Maine. So the other 21 certified states have not adopted this proposal, and as of yet, the FCC has not. So this is definitely an outlier proposal by all definitions. But even assuming or accepting for purposes of discussion the underlying premise that there's some benefits to the utility or to its ratepayers, that's ultimately a decision for the commission, but we would submit that there really isn't. And if there is, it's very speculative. And part of that is because some poles are never going to be replaced due to targeted underground projects. Now, it's not going to be a whole lot of poles, but it's going to be some. But it also presumes that at the time of a make-ready pole replacement, the electric utility is going to know what type of pole it is going to need for core electric service at some unknown point in the future when that pole has to be replaced. And if, for example, the make-ready solution involves changing out a 40-foot Class 5 pole with a 45-foot Class 3 pole, but then 12 years down the road, when the pole actually needed to be replaced, what the electric utility needs is a 50-foot Class 2 pole, then that 45 Class 3 put in as part of the make-ready pole replacement is of no benefit whatsoever to the utility or the ratepayers. And even if you could project what that future need would be at some undetermined point in the future, you then have a cost pairing issue because you're essentially forcing today's electric ratepayers to pay for costs that are not necessary for the provision of their electric service. And so for all these reasons, we think that this proposal should be rejected and that it is an outlier and that it would be a disservice to electric ratepayers in Kentucky.
Did anyone else, I think I understand the issue. Does anyone else have a comment on it, though?
Ben, this is Deb. I just might make this comment. I'm going to try and sound very unlawyerly here and be pragmatic. What we're talking about is the cable companies commission adopt something that to get in front of the FCC and adopt a regulation that one state in the country has adopted to address something that the commission already has jurisdiction over. Also, the commission's initial statements when it first proposed regulations indicated cost issues were going to be later and think that can be done effectively later.
Yeah, this is Chris. I just wanted to make a point. You know, we have an example in the state of Kentucky that where multiple companies have provided broadband in our area. And we have some very low pole attachment rates for cable companies across the state, even below the FCC rate. And we just don't think that the full costs are allocated. That's a discussion for the commission. But you know, I think it's fair to say that, yes, pole costs are an issue, but you know, we serve these areas. And where there's 1 and 2 customers per mile, that becomes a revenue problem. It just is. I get that, and I appreciate that serving these areas is expensive, and there's very little revenue. But you know, I would contend that that is certainly a bigger part of some of these serving areas than some of these make-ready costs. And to the benefits of a cooperative, it's very, very little. You know, we don't have as many attachers in many places. So asking us to change a pole, not offsetting the cost. certainly, we believe, presented a significant shifting of costs to our ratepayers.
Excuse me, this is Jeremy Gibson with Duke Energy. Paul, would you mind going on mute? I think we're getting some feedback from you. Thank you. So yeah, and this is just I guess my personal perspective, but it sounds like we're getting asked, the utilities are getting asked to subsidize make-ready costs and pass it on to our rate base, and I don't understand how that could be fair to a rate base that may or may not even utilize those communication companies. Yet they're paying for something to help them streamline, and they might never even use them as an attacher. So I don't know. To me personally, I don't see how that would be fair to our rate base.
And this is John LaFollette, excuse me, with LG&E and KU. And I just wanted to add, some quick comments about statements that have been made both in this meeting and that are floating around on the internet on a website that we've come across. It's sponsored in part by KBCA, so it's relevant, I think, to this meeting regarding how utilities manage pole replacements. There's a statement that's been made that utilities somehow wait for attachment applications to come in that will require a pole replacement before moving to replace a pole that is moved beyond the end of its useful life or is somehow defective. And that's just 100% not true as it relates to LG&E and KU. In fact, LG&E and KU have a very proactive approach to replacing poles that are either problematic structurally or at the end of their useful life. We have a pole inspection treatment program that has, over the last 10 years, resulted in the replacement of some 120,000 poles out of a plant of over 600,000 that we're attached to. And so to suggest that, we're waiting for an attacher to come along to request a replacement so that we can get a pole for free, for one, it's not true. And for two, it's an affront really to our approach to safety and reliability of our electric system, because as everyone knows, the poles are obviously a critical asset when it comes to supporting our electric distribution lines. Secondly, with respect to poles that need to be replaced, if there's a pole that is, it's been inspected and it's on our, to be replaced or meets our to be replaced criteria, and it happens to be part of a pole attachment application, LG&E and KU already replaced that pole at our cost. So again, the suggestion that the attacher somehow has to replace our bad plant is just not true as it relates to LG&E and KU, and I think it's important to clarify that as we discuss this topic in general.
John, this is Jeremy with Duke Energy. John, thanks for bringing that up. I saw that website as well and fully agree that as at least with Duke, that is a complete false statement.
Same for Kentucky Power.
Yeah, that goes for the cooperatives as well. Every 2 years we get around our system as requested by our PSC, and I read initially, safety and reliability is critical to us. From the Ike and Ice storm, why in the world would we wait for replacing poles like that? We just don't. We just do not do that. That is against everything that we stand for. So we disagree completely. And thank you, John. The cooperatives echo that across the state.
I mean, Ben, I have, and I'll leave Paul to field this. I mean, I'm not, I guess I'm comfortable with some of the comments that others have made about how to conduct themselves, but I haven't heard really anyone substantively engage Paul's explanation of our proposal in terms of the merits and the equity of it, right? Paul went through a very detailed operational explanation of how costs would be allocated and the circumstances associated with that allocation. And I haven't heard from anybody that methodology seems unreasonable, right? I mean, we're talking about something in a very real and detailed manner, and I haven't heard that response where somebody kind of walked through point by point and challenged Paul's characterization of what we're asking for and kind of pushed back in a very direct way on it being unreasonable.
Well, I must not have done a very good job, because that's precisely what I was endeavoring to do with my remarks. And though I didn't address the cost methodology itself, I did attempt to address some of the underlying equities, which is why I mentioned whether it would be of benefit at all to the electric ratepayers. But addressing the cost methodology, the data that AEP through Kentucky Power submitted, which was part of their filing in the FCC, indicates that this proposal would have the effect of essentially shifting 90% of pole replacement costs to the electric utility and its ratepayers. So in essence, the attaching entity would bear 10% of the cost, the electric utility and its ratepayers would bear 90% of the cost. And given the speculative, questionable benefits to the electric utility and its ratepayers, that does not seem like an equitable allocation at all. And as Pam, John, and Jeremy and the co-ops explained, if a pole truly is in need of a change out because it is rotten, that is not a cost that's being forced onto attaching entities. And so if there needs to be some sort of rule addressing that scenario, I'm certain that something could be worked out. But when it's a make-ready pole replacement in the normal course, it does not make any sense from a cost allocation or equity perspective for 90% of that to fall on the electric utility and its ratepayers when they have no present need for that at all.
Yeah, if I can just say one more thing. The situation in Maine was described as an outlier, and that's really not a fair characterization. Maine is, as I to my knowledge, really the first commission to focus on this particular cost allocation issue in the context of promoting rural broadband deployment. And that commission there considered all of the issues that are being raised by the utilities here and decided that the proposal that the Cable Association is recommending that the commission adopt here is fair, appropriately allocates costs among the pole owners and the attachers, and that it will promote rural broadband, which is why the commission undertook this proceeding to begin with. So just on that, it's not that Maine is some kind of outlier. Maine may be on the vanguard of considering this issue, but as I noted, this is something that's being considered now actively at the federal level, and the first state commission to consider it has decided that this is a pro-broadband deployment rule that's fair and appropriate.
This is Jeremy with Duke, so I might be going a little down the rabbit hole here, please, and excuse me if I do, but so if you're in essence saying that, you all would only pay a certain amount of value, that it's to help build out the broadband and this and that, things like that. If a utility was to go in and put a brand new pole line in to feed a subdivision, would we in essence have, be okay to bill you all for part of that? As you might be there in the future?
We of course, as you know, already pay our fair share when we go out and attach to those poles.
When you're attached to the pole, correct. But if that pole is only served for that point as a utility purpose, and you come along later and want to attach, you're saying that we should our company should subsidize part of that cost and pass it on our rate base. So why would you not pay for any of that up front? Because if you're expecting a break on the cost earlier, later on when you come along, why wouldn't you pay for it up front? That you might be there in the future to help cut down the electric cost.
That
I'm just playing both sides, that's all. I'm just asking if anybody understands what I'm saying. It seems like we in essence could ask the same thing of you all if we're putting in a new pole.
I mean, in essence, and Paul, correct me if I'm wrong, we do pay for that pole in the rate base of our rental rate on other poles. So
Yes.
when you put in a new pole and we're not even attached to it, we pay for the capital costs of that pole as part of the pole attachment rent. So, and new poles increase the rate base of the pole attachment rent. And so, yes, we do pay for that pole.
Even though you're not attached, you're paying for poles.
Yeah, indirectly, because it's part of the rate base that factors into the formula. It goes into your FERC 364 account. And so.
I understand how they calculate, yeah.
We're not paying directly for that pole, but we are paying it as part of the rental rate base.
I think it should be pretty apparent to the commission. This is obviously a very thorny issue, but that's the reason why I don't think we have to do that right at this moment. But to the extent the commission is interested in thinking about it, there are any NRECA comments that were filed at the FCC on this very issue that might be enlightening about that, and we'd be happy to file a copy of that record as well.
I would appreciate that, Mr. Depp.
Jeb, can I ask a question? Is that okay?
Oh, by all means. The vice chairman has joined us, people.
Yeah, Chandler. Just a question on this, and maybe it's to that point, Tip. Do the individual parties or the sides, whatever it may be, attachers versus utilities, does anybody care one way or the other? And I take from this conversation that may be the case. Whether this is addressed explicitly in regulation or if this is effectively punted, to be done on an ad hoc basis or through agreements. And the only reason I ask is I don't know of many other places that the commission's regulations specify what the rate-making treatment of a specific action is going to be in law. Now, maybe that's a good thing, maybe that's a bad thing, maybe it needs to be done, I don't know. I'm just asking the parties' positions on does this need to be explicitly in the regulation one way or the other.
And I don't know when you joined, Mr. Vice Chairman, but that was exactly the point I was making earlier, is that the commission has jurisdiction to address these sorts of things separately, and that's why we should not delve into this mess here.
I guess, Mr. Vice Chairman, this is Mike Chwanek from Charter. Good afternoon. In a general sense, I think from our perspective, there is a sense of importance, and I would argue kind of broader policy consideration here that would merit this issue being addressed, in the context of these regulations at this time. Based on our experience in other states where we've been managing, significant build out, giving guidance on this particular issue in the manner that we're suggesting would have impact on broadband deployment. We're not talking about this issue from a speculative standpoint. I think we're talking about this issue from the standpoint of how we've managed significant build out in other jurisdictions. And, we feel that it would be important for the commission to address it in this process.
So who else puts that in regulation as whether they reflect the marginal cost versus the embedded cost? Does anybody else put that in regulation, or is that policy made other places, or is it the case law or the precedent as to how they treat these expenses or these replacement costs? Now, because what I'm asking is, I get the idea of wanting the benefit of certainty, or at least knowing what the rule is going to be, and I kind of want to bifurcate that from the conversation as to insofar as the commission's going to provide certainty. Is it better to do it in the ad hoc was probably a wrong term, but is it better to do it in a different forum or in the regulation? I guess what I took from your response is that the preference from charter at least would be for it to be in the regulation, regardless of where the commission provides the certainty. Is that fair?
I think that's fair, but Jill or Paul, you may want to speak to that in more detail.
Yeah, thanks, Mike. I was just going to add in that, yes, the one commission that so far has addressed this has expressed it in a regulation, and there are important reasons why, including all of those that Mike just mentioned. It gives certainty to this important issue. And as I noted kind of in the outset of this discussion, these costs around pole replacements are profound when it comes to deployment in rural areas. So having that kind of certainty on the cost side as the broadband providers contemplate and make business decisions around these kinds of builds is hugely valuable and important, and we would advocate for this rule to be set out in a regulation.
All right, I appreciate it. I wanted the perspective on that. Thank you.
Any other comments on this topic? I think we only have 7 minutes left. I don't know. Was there anything that didn't come up that that anyone thought was critically important to discuss at this time?
Yeah, I'll say this, Ben, that, you know, if there are a lot of other issues on the table, perhaps what we can do is that we can schedule another meeting sometime in early January to address those topics. I don't know if we need to necessarily linger past 1 o'clock. I'm sure a lot of people have made arrangements for other video meetings and the like of that. Would the participants be well, let me poll you on this. Do you think that there are sufficient remaining issues that we should reconvene virtually sometime in the new year, or do you think we've covered enough ground today?
This is Jill. I would like to cover some more ground, if that's possible.
Okay. Anybody from the from LG&E, Kentucky Power, the RLX, AT&T?
This is Eric Langley, and I think that another session would be useful. There's a couple of the big issues that I had outlined in the opening remarks that we still need to touch on.
This is Tip Dep. We would join in that.
Yeah, and Ben, I don't know that it would be unreasonable, for the parties to kind of identify those issues, right? So that we had a sense of the list in advance, and that would help us be, more prepared and more efficient, because I think it's in our collective interest perhaps to make the second session the last one. So this way we would kind of scope that out, and you'd be in a position to manage it more effectively.
No, I think that's fine. And I did have a couple other questions myself, but depending on your all's interest, I was, gonna either leave them on the table, but it sounds like you all are interested, so
yeah.
I can bring up them. But Jeb, I don't know how you would want to handle them kind of,
I think what I would
indicating issues you'd like to discuss.
Well, I think what I would propose, if the interested parties could get together, I will. Well, first I'll look at the commission calendar and see what is available starting in January, and then if you all in the meantime would get together and see if you can condense the issues, or at least put them into a cohesive format, what you'd like to speak. You could share that with me, and I will share the commission staff's remaining inquiries. As you know, Mr. Bellamy is curious on a lot of these topics. And that way, when we finally do reconvene, we might have a little bit of a format. I have to confess, I think I told Jim Garner that this was not a half-baked idea, the way I was going to conduct the meeting, but really only 3/4 baked. And I think it has been productive, but I think that if we have a little more guidance of what the topics are and perhaps the order in which we address them in the future, that we can do that. Does anybody have any concerns with what I have proposed?
No.
Hey, Jeb, it's John Tyler with AT&T. I don't think there's a problem with that. It is somewhat amorphous, though. So if we can have a document that states kind of where the parties have come out to date, so that we're not rehashing everything, and we kind of distill it down to remaining issues, that might be helpful, but AT&T will certainly participate.
Okay. All right, well, I think that that might be a good spot to leave it. What I will do is I will email the regulatory group once I get an idea or a date certain, and then you all, once we have that, we can work backwards in the dates where we can get the documents that we've mentioned and the topics that we want to discuss. So I do appreciate everybody coming together, and my gosh, you guys are incredibly well prepared and really know the topics. I feel kind of like a judge sitting up here, and I've not really had to do anything, so maybe I am kind of like a judge, and always complimenting everybody for being so well prepared and so knowledgeable on the topic. So with that in mind, does anybody have any closing issues? We are going to reconvene, so we don't need necessarily closing comments.
No.
No.
Jeb, this is Jim. I appreciate what AT&T just said about you all summarizing things. I think our preference would be to have the meeting as soon as possible if that would end up delaying the meeting in early January.
Okay, well, we will work on that internally to try to get a summary of what we've discussed before or discussed today, or what you all discussed. I've been relatively quiet. Just so that we can make some progress towards getting this regulation, hopefully through the front door of the Legislative Research Commission at some point. And that's when the real fun begins. So, all right. Any other comments or concerns?
No, thank you to everyone.
All right. I do appreciate everybody's help, and we'll be in touch with you all. Thank you very much. All right.
Thank you.
Thank you.
Thank you, everybody, especially Ben. Thank you, Ben.
Thank you.
Bye.